For reasons mentioned in the order, the prayer for bail is rejected in both the cases. The petitioner is allowed to go on bail of rupees 50,000 with one surety of life, subject to certain conditions. The petitioner is allowed to go on bail of rupees 1 lakh with two sureties of like amount with certain conditions.
DPO.
The petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount. The petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount.
May please, your lordship. Lordship, I beg to mention for listing a criminal petition for motion for Monday, lordship. Recall of NVW, lordship.
Okay.
Oblige, your lordship.
Lordship, I beg to mention for listing of a criminal revision petition. Lordship, kindly fix it on either 16 or 18th of September.
Next week on a date to which it's registry. Next week on a date to be fixed.
As per order dated 25/6/2025, it was supposed to list it after 3 weeks, but now it's more than 6 weeks.
Next week on a date to be fixed by registry.
If I'm praying for listing of an IA lordship in a bail, the interim bail has been granted by this court on 3/9/2025, but subsequently some new section has been added. So I have filed an IA. Maybe taken up tomorrow.
When have you filed?
Yeah, on 8/9.
Tomorrow may not be possible.
On Monday.
Monday.
May please, your lordship. Praying for listing of a criminal petition. The urgency remains is that on Monday, the accused are supposed to appear. And the fact remains that Thursday, Friday, Saturday, these are holidays.
When have you filed?
Yesterday. So we are praying for this last item also tomorrow.
No.
Last item or at 2.
When have you received the summons?
Summons have been received 2 weeks back,
Monday, on Monday.
Lordship, accommodate tomorrow at last item also.
Tomorrow it may not reach. We have.
Or at 2, my lord. The urgency is only that one. And the one of the accused is
No, all other.
student. He's
We will see tomorrow.
At least, your lordship. Okay, but 8 of today's daily list, your lordship, some typographical error has happened. So I'm praying for withdrawal. My lord may allow me to withdraw the liberty to fetch.
Heard Mrs. Zia,
Item.
learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant anticipatory bail application as some typographical errors have crept in the bail application. The prayer is allowed. This anticipatory bail application is dismissed on withdrawal. Liberty, whenever you have apprehension, you can approach.
Pray for listing of 2 IA for suspension of sentence next week, my lord.
Next week on a date to be fixed by registry.
So, lordship, I beg to mention a bail application, regular bail application for listing, lordship. It was last listed on 4th and CD was fixed for. As per my knowledge, CD was arrived, lordship. Kindly on Monday, lordship.
No, you cannot choose. Next week on the date to be fixed by registry.
Oblige.
No, I beg to mention a listing of criminal petition, 21 matters, my lord. There is some urgency because if they appear. So next week, my lord.
Next week on a date to be fixed by registry.
May please, your lordship. Lordship, I beg to mention lordship for listing lordship, bail application lordship.
When have you filed?
Yesterday was filed,
Wait till Monday.
Monday.
If on Monday it does not get listed automatically, then you approach this court for mentioning.
Till Monday.
No, let the registry do its own work. If it does not get listed, only then you may mention.
May it please, your lordship. I beg to mention one criminal petition for withdrawal, lordship.
When do you want? Okay.
May I pray for listing of the matter, my lord, for orders, my lord, criminal petition.
Next week on the date to be fixed where it is.
Maybe lordship, criminal petition, lordship. Trial court is fixed on lordship 15, lordship.
Next week on a date to be fixed where it is.
Monday, lordship.
No,
Trial court date is fixed on Monday, lordship.
why have you approached so late?
For a criminal petition for quashing, lordship. Both parties are.
Next week,
compromised.
next week on a date to be fixed where it is.
May please, I pray praying for listing criminal appeal along with the miss case, my lord. Appellant is behind the last 6.
Next week.
Obliged.
Like to mention a regular bail application, lordship, for bail hearing, lordship, any day next week.
Okay.
May I please the
Date
lordship?
shall be fixed by registry.
Obliged.
I beg to mention for listing one criminal petition, lordship. Can it be on Monday, lordship?
No, you cannot choose the date. Next week on a date to be fixed by registry.
Listing of item. Okay, much obliged, lordship.
May please, your lordship. I beg to mention item number 47, my lord.
Yes.
Here, TCR was called for, my lord.
What is your submission?
My lord, it may be taken up next week, any day, my lord.
Why?
Today, the leading counsel is having some difficulty, my lord, in this.
Heard Mr. What is your name?
Bijal Lugda.
Heard Mr. B.J. Talukdar. Learned counsel for the petitioner. Yes. Also heard Mr. K.K. Parashar. Learned counsel for the petitioner has prayed for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
May I please, your lordship, I beg to mention, criminal evidence petition 87/2025 for listing. May it be listed on Monday, your lordship.
Next week on a date to be fixed by registry.
Obliged.
Your lordship, I am praying for listing a criminal petition matter. Maybe listed on Monday, your lordship.
Next week on the date to be fixed by registry.
Your lordship, matter was fixed this week, lordship. But it is not in the list of lordship. So, yesterday, tomorrow is also printed out, lordship. Can it be in the next week? I'll share receive, my lord.
Next week, okay, on a date to be fixed by registry. You
Next
give,
week. Next week, lordship, I have some personal difficulty. That is why dates is required, lordship. Can it be on 16 or 18 line, lordship?
okay, on 18th.
18. Obliged, lordship.
May I please, your lordship, I beg to mention for listing of a motion matter, lordship.
What? Bail,
Lordship, criminal revision petition, lordship.
next week on a date to be fixed. No, when have you filed?
Lordship, last week, lordship,
When?
Friday, lordship.
Last Friday. It
Last
has
Friday.
not yet been listed. Okay, Monday.
Much obliged, lordship. May I please, lordship? Lordship, in this case, the petitioner was arrested on 6th February 2020 and forwarded on 7th February 2020. That is 5 years, 7 months and 8 days. Out of 10 witnesses, lordship, 5 has been examined and the last witness was examined on 19 November 2024.
Since then, no witness has been examined.
Next date for evidence is lordship 10th October 2025.
What is the contraband seals?
It's 420.2 kg of cannabis.
Yes,
Okay, your lordship, contraband was 420.2 kgs of ganja recovered from the.
yeah, but 5 years is too long.
Okay, why trial has been delayed, I will not be able to assist it because lordship LC are not received. But lordship till now I have received the 5 witnesses have been examined out of lordship 8, lordship 8. Each of witnesses not there, lordship.
The Trial court records was not called for. Today is the second, we will call for the trial court records.
Moreover, Lordship, grounds of arrest was not in the notice of notice under section 15.
To verify that, we will require trial court records. Miss, you have filed any written objection? Do you have any objection in granting bail? Otherwise, we'll allow them to go on bail.
Your Lordship, I will be able to assist you, Lordship. My trial has been. Lordship, length of detention may be considered, Lordship.
But we don't know who is at the fault. Heard Miss S. Naz.
Petition.
We'll fix it before vacation. Heard Miss S. Nazneen, learned counsel for the petitioner. Also heard Miss M. Deka, learned counsel for NCB. It appears that in this case, the petitioner has been detained behind the bars for more than 5 years, 6 months. However, the trial court records are not before this court to consider the submissions, to appreciate the submissions made by learned counsel for both sides. Hence, let the scanned copy of the trial court records be called for. Let this case be listed on before that. 19th September.
Have your bless.
Item 4.
May I please the Lordship? Hello, POCSO is there, Lordship. There's only 57 days, Lordship.
POCSO,
Yes, Lordship. 57 days, Lordship, as on today.
heard Mr. M. Khan, learned counsel for the petitioner, also heard Mr. K.K. Parashar. Call for the case diary and issue notice to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within 3 days from the date of this order, returnable on 24th September.
5.
Yeah, please. Matter is regarding POCSO.
Heard Mr. I. Islam, learned I. Islam, Baki, same order, earlier order. Call for the date 24th September.
Item 6.
24/9.
May I please, your Lordship, for ATT application, Lordship, petitioner was arrested on 7/10/2023. Today is about 1 year, 11 months, 2 days. And Lordship, in this case, from my position, nothing was recovered. I was in the other bird and contraband recovered from some other bird. Lordship,
This is your first bail application.
Lordship.
We'll call for the scan copy.
Taking the plea of non-compliance of section 50 CRP.
Then we'll call for the,
An extra copy, certified copy of this, Lordship. At page number 27, Lordship.
how much is the contraband
Contraband is to 42 kg, Lordship,
of?
in 2 bags, ganja.
Heard Miss S. K. Nargis, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Let the scan copy of the trial court records as well as scan copy of the connected case diary be called for. Let this case be listed again.
It's from Kamru Metro, Lordship. Can it be before Puja vacation, Lordship?
24th of September.
24th of September. Oblige, Lordship.
Item 7.
May it be the law. FIR Roshipul at page number 7.
allegation is that of kidnapping, your lordship, 365 IPC or 143 PNS.
We'll call for the case diary.
In this case, he is in the judicial custody. The girl recovered on that very day itself. Kindly go through the FIR, your lordship. Page 7.
No, why your prayer was rejected by the,
Yes, that is also I have an.
after perusal of the
Perusal
case
of the
diary.
case diary.
So we have to peruse the case diary. Heard Mr. M.H. Laskar. How long you are behind the bar?
24 days.
Heard Mr. M.H. Laskar, learned counsel for the petitioner.
There is-
Also heard Mr.
In the
K.K.
affair, there is no other allegation that kidnapping. Girl already recovered on that very day. Their father called me up and immediately I left. I am an auto rickshaw driver, your lordship. I was taking her. In between, father called me up, said that why you are taking my daughter. I left the girl there and asked her to go back to home.
We
There
have
is no
to be-
further allegation.
My
your
lord,
lordship.
no, it is
FIR lordship will
reflected
kindly
in FIR, my lord, it is reflected in the order, my lord. This outraging the modesty is also there, my lord, page 16, para 7. Perusal of the case diary reveals that the accused
Even if
person.
it is
Call for the case diary. Let this case be listed on 20.
When this is on record, he should not say that only kidnapping.
No, what I'm saying on FIR, I am saying.
23rd September.
So he has annexed.
Obliged.
Four eighty-three bail application, lordship. He is a student of IIT Guwahati, lordship, who was arrested from a spa, lordship, in at Ulubari. When he fell down outside in the street, then he went for a message in the parlor. And the police raided the parlor and picked up the owner of the that spa, as well as the one lady and that student, petitioner, lordship.
Why your prayer was
He
rejected?
fell down, got some injury.
No, why your prayer was rejected?
My prayer on it, it is stating about an ascent stage. But without considering that, lordship, kindly turn to page 14, annexure 1. In the first, second column, lordship, it is stated that the commission of offense on 4/9/2025. Information received on 5/9. It is very small, lordship, I could not typed it to 5/9/2025. Information received on 5/9. And then they have raided that spa, lordship, on 4/9. There is a discrepancy in the FIR, and he was arrested on 4th and locked and picked up with both the owner and manager of the spa. He is a student, lordship. If he will be assumed but not admitting that he, being a customer also, he cannot involve in any offense, and all the sections in which the case has been registered are not affected in case of the petitioner, lordship. And his midterm examination is due is scheduled on 14/9, lordship. So considering this aspect,
14/9.
this 14/9 figure starting
49
14/9.
is Sunday.
Yes, lordship. From Sunday to the start. I have given that is for
What examination?
midterm examination IIT Guwahati.
Where is that?
Yeah, page 25, annexure 4, lordship. This is fourth, it is started his examination on 15th. Page 24, 25. And all the sections are not attracted in his case, lordship. He is not a trafficker.
What he is studying now?
Now he is, that is, lordship, he is studying in science. I have a, that is the post doctorate student of a profession, enroll in the Center for Linguistic Science and Technology, IIT, and MS course. Dual.
Now this routine is for which examination?
Midterm, that is, I have mentioned in page 9, paragraph 12, lordship. The petitioner stated he is pursuing dual degree, MS and PhD in the IIT Guwahati. The semester examination for MS degree is scheduled on 14/9. And
Where have you stated page?
Page 9, lordship, paragraph 12.
What is MS?
Master of Science and
Yes, Mr. Parashar.
Lordship, interim bail may be granted after perusal of city lordship because he is due and
He's the
all
only
the sections are not detected.
Okay, we are granting interim. Heard Miss.
Otherwise, he is the only customer or others, it can be.
Heard Miss M. Dev, learned counsel for the petitioner. Also heard Mr. K. Parashar. This application under section 483 of BNSS has been filed by the petitioner Chaitanya Kirti, who has been detained behind the bars since 5/9/2025 in connection with Paltan Bazar PS case number 268/2025 under section 143 within bracket 3/144 within bracket 2 of BNS 2023. Read with section 3 within bracket 2 within bracket small b /4/5 within bracket 1 within bracket small d /6 within bracket 1 within bracket small b of Immoral Traffic Prevention Act 1956. The accusation against the petitioner in the FIR lost by one. One Uddhav Pathak, former SI of police, before the officer in charge of Paltan Bazar police station is that on 4/9/2025, when the raid was conducted,
4/9 lordship.
Malak,
on 4.
But information received on
No,
5/9.
detailed information on 5/9 in FIR, but GDNP there, page 18.
4/9/2025, the petitioner was found in a salon, that is Fablux Hair, Beauty and Spa Salon at Seema Plaza Building, Ulubari, and was found indulging in offense alleged in the FIR. Learned counsel for the petitioner has submitted that the petitioner is a student of MS and PhD. At the same time, you are student of Masters of Science and
Yes,
PhD
they can do lordship as per my instruction.
at IIT Guwahati, and his midterm examination, mid-semester and end semester examination are scheduled to be held from 14th of September 2025. She submits that none of the offenses are made out against the petitioner. And she also submits that as petitioner is a student, unless he is granted some interim protection, his academic career would be ruined. Stop. On the other hand, learned additional public prosecutor has prayed for calling of the case diary. Stop. Call for the case diary. Let this matter be listed after 17th of October. However, in the meanwhile, considering the submissions of learned counsel for the petitioner as discussed in the foregoing paragraph, and considering the fact that from the notice / routine of the examination, a routine of the midterm semester examination produced by the learned counsel for the petitioner, it appears that the midterm semester examinations are scheduled to start on 14/9/2025, the petitioner is allowed to go on interim bail till next date fixed on furnishing a bond of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate,
Kamrup Guwahati.
Kamrup Metro,
Metro.
Kamrup Metro, with following conditions, number 1 and number 2. Stop. List accordingly.
Complete.
Item 9.
Yes.
Yeah, please. Okay. This is a 482 application. Okay, FIR at page number 18, sorry, Your Lordship, FIR at page number 16, Your Lordship. Kindly page is the page number 16, Your Lordship. The FIR.
Yes.
May I read, Your Lordship?
Yes. What is the offense?
Offense is under section, Your Lordship, 351 clause 2, 352, 353, 356, 324 clause 2, and 115 of BNS, Your Lordship. Apart from 353 clause 3, all the sections are available in nature, Your Lordship. Moreover, Your Lordship, one of the co-accused has already been granted interim protection, Your Lordship. I have annexed it on Annexer 5. So kindly go through the page number 23, Your Lordship. In connection with this case, Your Lordship, one of the co-accused has already been granted interim bail. Page number 23.
What is your case?
Well, the case is that there was some physical altercation between two parties, Your Lordship. So after that, the informant, as per the allegation is concerned, he was sustained injury. Accordingly, the police registered this case, and as Jalukbari PS case number 157 of the 2025 under section all whichever I have mentioned, Your Lordship. But the thing is that, Your Lordship, the informant in connection with this case, he assaulted the present petitioner number 1, Your Lordship. And he sustained.
Why 353 has been included?
Your Lordship, if Your Lordship go through the FIR itself, the section 353 doesn't attract it at all, Your Lordship. 353 clause 3 attracts the religious places or something like that. However, in the FIR itself, it is called.
Okay, when the case diary is called for?
At 9:30, they have come and assaulted the informant by brick in his head, injury is there. When the elder brother came, page 11, the elder brother was also assaulted by brick, iron rod.
Who assaulted?
The informant, Mukesh Papa and Rahul Das.
But however, Your Lordship, that Rahul Das has already been granted interim protection by this honorable court, Your Lordship. I have annexed the said in my petition Annexer 5, Your Lordship. Kindly go through the Annexer 5, Your Lordship, at page number 23.
Why except 353 other offenses are bailable?
However, section 353 clause it doesn't attract it in my case, Your Lordship. If Your Lordship go through the whole FIR.
Yes. Heard. Mr. What is your name?
SD Roy, Your Lordship.
SD Roy, learned counsel for the petitioners. Also, Mr. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioners, namely Mukesh Thapa, number 2 Bishal Das and Bishal Das, who are apprehending their arrest in connection with Jalukbari PS case number 359/2025 under section 351 within bracket 2/352/353 within bracket 3/356/354/2/1152 of BNS. The gist of accusation in this case is Code Para 3 from page 24. Learned counsel for the petitioner has submitted that in the meanwhile, two of the co-accused, namely Konkan Pathak and Rahul Das, have already been released on bail. He also submits that all the offences involved in this case, except the offence under section 353 within bracket 3 of BNS 2023 are bailable in nature. He also submits that the facts alleged in the FIR do not indicate any ingredients of offense under section 353 of BNS. Stop. On the other hand, learned additional public prosecutor opposed the grant of any interim protection at this stage and prayed for calling of the case diary. It also appears that in a connected case, that is AB case number 2053/2025, case diary has already been called for and the next date is fixed on 19th of September 2025. Stop. Let the case diary be called for in this case. Now, however, Code Para 7, you appear before the IO within 7 days.
Hello.
And if you appear, then 30,000 with one surety interim bail.
Much older.
Code Para 7 and 8. List accordingly on 19 September. 19 September.
May it please your lordship. Pre-arrest bail application, your lordship. The FIR is at page 15 vernacular, your lordship. Allegation of theft, dishonestly receiving the stolen property and cheating, your lordship. The petitioners are not named in the FIR. One
one AB is fixed on 24/9 CD call AB number 2190/25.
21.
AB 2190/25 Kalyan Pator. Order dated 8/9/25. Fixed on 24/9. Interim was
In this,
interim granted, lordship.
what is your case?
My case is that I am not in the FIR and one arrested accused, your lordship, which is at forwarding report is at page 17. He, as per police, he named petitioner number 1 names that he has purchased the stolen article from petitioner number 1. And in respect of petitioner number 2, there is no allegation, your lordship, but police is searching him, your lordship.
one whole tons of iron were sent from here.
So we will not grant bail to one.
Yes, one is not.
One after perusal of the case diary.
Lordship, till lordship.
No, on what ground you are seeking interim bail?
Only lordship, police, I have apprehension and there is, as per police, your lordship, that the arrested accused told the name of petitioner number 1.
What is your submission?
No, Lordship, I have stated that I have not, no any,
Heard Mr. A.R. Shom,
shown, Lordship.
learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioners, namely Tinku Sadhanidar and Dipen Deka, who are apprehending their arrest in connection with Sonapur PS case number 130/2025 under section 303 within bracket 2/317 within bracket 2/318 within bracket 4/61 within bracket 2 of BNS. The gist of accusation in this case is that on, where is the affair?
FIR translated copy page 13, Your Lordship.
On 16/8/2025. One Pinku Kumar had lodged an affair that he had hired a vehicle, a 14-wheeler open-body truck bearing registration number AS01JC 5643 for transportation of 16.5 tons of tin from Kamarkuchi to Silchar. And for that purpose, one driver, namely Utpal Das, was assigned to take the goods to Silchar. However, it is alleged in the affair that after the goods were loaded in the truck, the mobile numbers of the driver was found switch off, and it is suspected that the goods have been stolen. Learned counsel for the petitioner has submitted that the petitioner has not been named in the affair. However, he has been informed that one of the co-accused has implicated his name in receiving the stolen property. The petitioner submits, learned counsel for the petitioner submits that the petitioner is innocent. Petitioners are innocent and they are ready to cooperate in the investigation. He further submits that one of the co-accused has already been granted interim protection by this court. On the other hand, learned additional public prosecutor has submitted that in a connected case, that is AB number 2190/2025, this court has already called for the case diary fixing 24/9/2025, and hence he prays that this case may be also listed on the same date. The prayer is allowed. Let the case diary be called for. Let this case be listed on 24/9/2025, along with bail AB case number 2190/2025. However, in the meanwhile, considering the submissions made by learned counsel for the petitioner, as discussed in the foregoing paragraphs, the above named petitioner is directed to appear before the investigating officer of Sonapur PS case number 130/2025 within a period of 7 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on interim bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions 1 and 2 listed on.
Oblige, Your Lordship.
May please, it is POCSO relating to POCSO lawsuit, and the FIR lawsuit will find page 10.
Treasury may be required.
And notice to the informant.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. K. K. Parashar. Call for the case diary and issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 24th October, September.
Case diary along with 164 statement of the.
It will be there if it.
So as per my instruction in 164, she has said that her family were compelled to lodge the FIR.
Let us see. List accordingly.
Item 12.
The forest department is one recipe was seized from the forest area.
Who is the for the prosecution?
Dixit Google was
You have given a copy of the
already
bill.
given- already informed. I was
Let him come. Will you inform him?
13. Wait, please, your lordship. In this application, your lordship, under 438, along with 442 and 528 of the NS, your lordship, we're challenging the order of the additional passengers number 2, where he has rejected the application for defreezing the account of the petitioner. The account of the petitioner has been freezed, and thereafter, your lordship, this has been filed for defreezing the account of that. So the impugn order is at page 44. We have challenged it on 2-3 grounds. One of the main ground is that as per section 102 within bracket 3 of CRPC, there has to be before freezing of the account or immediately thereafter. The
It
IO
is
has
pending investigation.
no, in this case, your lordship, charge sheet has been given.
Charge sheet has been there.
We have so at this stage. your
Where is
lordship,
the impugn order?
that is at page 44. Page 44. Your lordship. Basically, your lordship, we are concerned with 2 points. First is, your lordship, that section 102(3) of the CRPC, which is a mandatory provision regarding intimating the concerned court, have not been done, number 1. And number 2, your lordship, the person concerned, they have stated that he doesn't have a regular income, but he has a shop, mobile shop, from where his income is regularly. And they have stated. And secondly, or thirdly, your lordship, for medical purposes, your lordship, the petitioner requires the money which has been freezed from the account. Their only ground is that this money has been deposited from your sale of contrabands and all. But that specific proof has not been given in the, your lordship, the charge sheet. We have not enclosed the charge sheet in this matter.
We would require the records.
Records. Lordship may issue notice and call for the records.
Yes. Heard Mr. Y. S. Mannan, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 438 of BNS, read with section 442 and 528 of the said code, has been filed by the petitioner, namely Khalilur Rahman, alias Syed Khalilur Rahman, impugning the order dated 7/7/2025, passed by learned additional session judge number 2, Kamrup Metro and Guwahati, in ND is case number 1/2025, whereby the prayer of the petitioner for defreezing the bank account of the petitioner maintained in the State Bank of India with account number 313522273330 was rejected. Issue notice. Since learned additional public prosecutor has appeared for the state, no formal notice need to be issued. Also call for the scanned copy of the records of NDPS case number 1/2024, as well as scanned copy of the connected case diary from the trial court. Registry to take steps for requisitioning the scanned copy. Please this matter 17th of October.
Obliged.
Item 14.
May I please Lordship? An application for quashing of a criminal proceeding in a POCSO case.
POCSO.
POCSO.
Charge sheet has been given.
First, it has been laid, my lord. It is pending for appearance. Only thing is that, my lord, the victim and the petitioner, they are related. So, my lord, a compromise has been arrived at, my lord, and the victim has been married to, my lord, some other persons. So, my lord, they do not want to pursue the matter now.
Let us issue notice. When is the date?
Let's take the process, you know.
Heard Mr. B.M. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528. You have, it should be
528.
528.
I'm sorry, my lord.
528.
528.
Correct it, my lord.
BNSS.
528.
Filed by the petitioner Abul Basa, alias Abul Bashar, praying for quashing of the criminal proceedings of special POCSO case number 182/2024. Stop. Issue notice to respondent number 2. The petitioner respondent number 2 and
3, my lord.
3.
Mother and the victim.
Respondent number 2 as well as respondent number 3. The petitioner shall take steps for issuance of notice upon the said respondents in pursuant to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 15th of October.
Next date is on, my lord, on 1710 day.
That day,
Before the trial court. 1710.
15th October. We are fixing it on 15th October.
Obliged.
15th October. Let also the scanned copy of the trial court records as well as scanned copy of the connected case diary be called for. List accordingly.
May I pray for my lords?
No.
Because there is a bailable warrant of arrest against me now.
No interim. No.
Obliged.
Item 15.
May I correct it, my lord, that 528 and 582, my lord, in my petition?
Action cannot be done.
Now the notification says that you have to file an amended plan.
Otherwise,
Learned counsel for the petitioner prays for allowing the petitioner to file an amended cause title due to some typographical mistake which has crept in the said cause title. The prayer is allowed. He may do so before the next date fix.
Obliged.
Item number 15. Yes.
May it please your lordship. My lord, petitioner, my lord, we had prepared a petition, my lord, that is page number 39, to recall the witness, my lord. PW1, my lord, and that petition, my lord, that was rejected on 4/8/2025. That is, my lord, impugned order dated 4/8/2025, my lord, operative part, page 47, my lord.
Page number 40.
47, my lord. Impugn order.
You have already cross-examined the victim.
Set of counsel, my lord, have cross-examined, my lord, but new set of, my lord, counsel, my lord, they prefer this petition, my lord, page 39, my lord, for under section 348, my lord, BNS, my lord, to recall the witness, my lord, PW1, my lord, that was rejected, my lord.
No, it was rightly rejected.
My lord, but to bring out certain truths, my lord.
Now, suppose you continue changing set of counsel, whether the victim will be recalled again and again.
For the ends of justice, to bring out certain truths, my lord.
Only the observation of the court, page 47,
It
second
is a
paragraph.
POCSO case.
POCSO.
So,
Page 47, second paragraph, PW carefully perused. Upon perusing the petition, it is said the defense has failed to disclose in the said petition what relevant materials was not brought on record by the previous counsel and what were the materials left to be cross-examined by the earlier counsel. That is not mentioned in the petition. That is one of the ground, my lord.
Why are you challenging? On what is your ground of challenge? How this order is erroneous? What is the wrong in the order?
Order, my lord, to bring out only for certain truths, my lord. My submission is that, my lord, and for the ends of justice, my lord.
Yes, Mr.
Otherwise, my lord, cross-examination for the ends of justice, my lord, I don't have.
No, but will you continue to
Yes,
recall
that is
the
also
victim?
again and again. And that too, my lord, the observation of the court below that they have not disclosed in the petition, my lord.
Okay, we are issuing notice.
No, otherwise notice has to be given.
Heard. Miss
RS
R.S. Devri, learned counsel for the petitioner. Also heard Miss Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner Lakshya Jyoti Tamuli, impugning the order dated 8/7. No, order dated
4/8, my lord.
4/8/2025, passed by the Court of Learned Special Judge POCSO, Sonitpur, in Special POCSO case number 46/2022, whereby the prayer for recalling the victim for the purpose of cross-examination made by the petitioner was rejected. Issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered post in pursuant to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 16th October.
Next date is 15/10, my lord. Till then, my lord, this proceeding may be stayed, my lord.
This is liable to be dismissed.
15/10.
Next date is
15, 10, before that, my lord, 13 will be maybe on 13.
no. Suppose your prayer is allowed, assuming that prayer is allowed, then the petitioner may be victim may be called at any stage.
At any.
So date is not relevant.
Yes, yes, yes.
Kiman dilo? 16/10.
16.
Right. 528 applications, my lord, against the order from Cognizance, my lord, which my lord will find at page 25, my lord, in an NIA case instituted against me, my lord. By this order, my lord, 23/6/25, cognizance was taken, my lord, under section 138.
When is the next date fixed?
Next date fixed is, my lord will find page 28. It was fixed on yesterday, my lord. Now refixed on 29/10/25, my lord.
We'll issue notice.
Yes, my lord. Notice, and then, my lord, primarily on sections, why I am challenging this, my lord. My lord,
Okay, let the notice go. Heard Mr. A.S. Tapadar, learned counsel for the petitioner. Also heard Mr. K.K. No. Learned counsel. State is not a party. State is also a party. Why? Also heard Mr. K.K. Parashar, learned counsel for the respondent number 1. This application under section 528 of BNSS has been filed by the petitioner Abul Kalam Khandakar, impugning the order dated 23/6/2025 passed by London Judicial Magistrate First Class Boregaon in CR case within bracket NI number 124/2024, whereby the cognizance of offense under section 138 of NI Act was taken by the court against the present petitioner. Issue notice to respondent number 2 and 3. The petitioner shall take steps for issuance of notice upon respondent number 2 and 3 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 17th of October, list accordingly. What interim? Your next date is on 29th.
deeply obliged, my lord. Item 17.
Make please a also, my lord. My lord, it's a criminal, quashing application, my lord, for quashing of the proceeding, my lord, before the pending before the additional chief judge, my lord. And here this affair, my lord, affair is at page 17, my lord. There has been the victim, she herself stated that they had long love relation, and even she had a live-in relationship. Although, my lord, the affair was registered under section 69 and 3082 BNSS, BNS, my lord. However, the charge sheet has been laid in this case, my lord. Charge sheet is page 23 under section 69 of my lord. Now, while the framing of charge, we argued the matter that ingredients for taking cognizance of 69 is lacking. She herself stated in the affair is a long relation, and she had a live-in relation with the the petitioner. So inducement part is lacking here. If there is, because she is also a major one, my lord. Here, my lord, the next date of this case, my lord, I have given the order, page 32, is fixed on 14/10, and the informant I have made a party, my lord. Respondent
Okay,
number 2.
Heard, Mr. What is your name? B.K. Das,
My lord.
learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely David Sonowal, impugning the, you have challenged the proceeding,
Proceeding as well as the affair, my lord, page 2.
impugning the praying for quashing of the
Yes.
affair as well as entire proceedings of sessions case number 124/2025 pending before the court of learned session judge
Additional
with
session.
additional session judge within bracket FTC Dibrugarh. Let the scanned copy of the trial court records as well as connected case diary be scanned copy of the connected case diary be called for. Let notice be issued to the respondent number 2 in pursuant to the prevailing notification of the registry. In this regard, the petitioner shall take steps for issuance of notice within 3 days from the date of this order, returnable on 17th of October,
But the next date is on 14th.
before
Can it-
14th,
Can it be?
13th of
Mal,
October.
Malad FIR, I have said FIR, search it as well as the proceeding. Search it is not, perhaps not given. FIR, search
FIR,
it. And the
FIR, one, FIR, comma, charge sheet.
Mal, oblast. Item 18.
Like, can it be taken out after some time?
Okay, after something.
DPO.
Item 19.
Yeah, please, Your Lordship, in this matter, Lordship, NBWA has been issued against the petitioner, Lordship. Page 25 is the order.
What is the case?
Lordship, FIR was lodged in the year 2020. The allegation of the informant was that his brother has been assaulted by the petitioner, Lordship. Petitioner and two other accused, Lordship, when he was returning home, Lordship. And thereafter, Lordship, search sheet has been filed, Lordship. And in the search sheet, the petitioner has been shown as absconder, Lordship. But during the period of investigation, police did not search for the police and petitioner, and petitioner was also not aware regarding the FIR, Lordship. So thereafter, on page 23, Lordship, the trial court, Lordship, take cognizance against the petitioner.
When is the next date fixed?
Next date fixed on 11/11, Lordship. I'm ready to appear. before
Let
the-
him appear.
Otherwise, the order, page 25, kindly page 25.
The bailable warrant of arrest was executed.
Yes, executed.
Why you failed?
Lordship, there was some inconvenience on his part,
He
Lordship.
filed an
And,
application.
pending of FIR, when a person attack with a knife, injured, and he doesn't know about the FIR, that is not very.
He's a permanent resident of Tezpur, Lordship, and police would have arrested him at that time also. But
You were arrested during
no,
investigation.
No.
You were evading
It's
arrest.
Could have been arrested, but police never searched for him. I'm ready to appear, Lordship. But due to this,
The charge sheet has been laid under what provision?
Page 20.
I have been shown as absconder.
What is the section under which?
Section, Lordship.
341, 326, 307, 34.
34.
IPC.
I'm ready to appear.
341, 326.
307
and
and
34.
34.
I'm ready to appear before the trial court, but some protection.
No, you have to justify why you failed to it. If there is valid reasons.
In the
What is the,
order, it is reflected showing some grounds. I have been.
where is your
my
petition? What grounds you have?
Petition has not been annexed here.
So how this court will know?
My advocate appeared and prayed for some time regarding for appearance, but it was rejected. And thereafter,
Okay, heard Mr. D. Chaudhary, learned counsel for the petitioner. Also heard Mr. A.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner, namely Kamaleshwar Boisho, who is impugning the order dated 17/12/2021. Now, which order you are impugning?
21/11/24.
Impugning the order dated 21/11/2024. Passed by learned judicial magistrate first class, Sonitpur, in PRC case number 1570/2021. whereby a non-bailable warrant of arrest was issued against the petitioner. Learned counsel for the petitioner has submitted that the investigating officer of the Edgewood PS case number 1477/2020 had submitted a charge sheet under section 341/307/326/34 of the Indian Penal Code in PRC case number 1570/2021, showing the petitioner name in the column of the absconder in the said charge sheet. Learned counsel for the petitioner has submitted that petitioner was unaware about the filing of the FIR as well as charge sheet, and during the period of investigation he was not arrested by the investigating officer. He also submits that the committal court had issued bailable warrant of arrest against the petitioner, which was duly executed. However, on the next date fixed before the committal court, that is on 21/11/2024, due to some personal difficulty, the petitioner could not appear in person before the said court. So it is submitted by learned counsel for the petitioner that on that day the petitioner engaged a counsel and through him had filed an application seeking adjournment. However, the trial court rejected the prayer for adjournment and issued non-bailable warrant of arrest. The petitioner, the learned counsel for the petitioner has submitted that the petitioner is ready to cooperate in trial. However, as pending non-bailable warrant of arrest is there against him, he is seeking some protection. Learned counsel for the petitioner also submits that the next date of the PRC case number 1570/2021 is fixed on
11/11/25.
11/11/2025. Stop. I have considered the submissions made by learned counsel for both sides. Now, there seems to be no irregularity in the order which has been impugned in this case, as the committal court had issued the non-bailable warrant of arrest only on failure of the petitioner to appear before it after a due execution of the non-bailable warrant of arrest issued against him. Stop. However, as the petitioner is ready to cooperate in the trial, this court for the ends of justice, by invoking its inherent power under section 528 of BNSS, grants interim protection to the petitioner, is inclined to grant interim protection to the petitioner. The petitioner is directed to appear before the Court of Learned Judicial Magistrate First Class Sonitpur on the next date fixed, that is 11/11/2025 in PRC case number 1570/2021. Stop. To facilitate his appearance before the said court, the non-bailable warrant of, the execution of non-bailable warrant of arrest issued against him by the said court shall remain suspended till that date, that is 11/11/2025. With above observation, this criminal petition is disposed of. Yes.
Yes, let him appear in 10 days, my lord, before the beat officer. And
Heard Mr. L. Gogoi, learned counsel for the petitioner. What is your name?
I brought her to my,
Also heard Mr. I. Thakur, learned,
on behalf of special PP Wildlife,
appearing on behalf of Mr.
D. Gogoi.
D. Gogoi, Special Public Prosecutor Wildlife. This application under section 482 of BNSS has been filed by the petitioner, namely Shri D.A.K. Thomas, who is apprehending his arrest in connection with offense number BG/WL/03 of 2025 under section 27/29/50 within bracket 1C and 51 of the Wildlife Protection Act 1972. Where is the FIR?
Offense report.
Where is the offense report?
Page 13.
Page number?
13. Annex R4.
The gist of accusation in this case is that on 16/7/2025, the forest beast officer Singlijan had filed a report regarding seizure of a JCB vehicle JCB vehicle which was used for clearing jungle inside Borgang range, and thereby the who are you? You are driver or owner?
Owner.
And it is also alleged in the said report that
I'm former owner, not present owner. Already sold the JCB.
that the driver of the JCB vehicle fled away when the staff of the Borgang Forage Range approached the spot. It is alleged that thereafter, the aforesaid offense has been registered. Learned counsel for the petitioner submits that the petitioner is the original owner of the JCB vehicle which has been seized in this case. However, he had already sold the said JCB to whom?
Here's the agreement letter. Page 11 and 30. To Mr. Nangrung Tongke of Onakal.
To Mr. Nongrung Tongke. However, learned counsel for the petitioner submits that the petitioner is no way involved in the offense alleged in the said report, and he is ready to cooperate in the investigation. We are disposing it of. Stop. On the other hand, learned counsel for wildlife department submits that if the petitioner cooperates in the investigation, he do not have any objection to the prayer made by the petitioner in this bail application. Considering the submissions made by learned counsel for both sides, this anticipatory bail application is disposed of with a direction to the petitioner to appear before Forest Beat Officer Singlijan, Vishwanath in connection with the offense report number BG/WL/03/2025. If he does so, and to appear before so and so, within 7 days from the date of this order, within 10 days from the date of this order, and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions. Number 1 and number 2. This anticipatory bail application is accordingly disposed.
My lord,
Yes.
my lord, request this put to dispose this matter, my lord, on motion. I am the complainant, my lord. The NI case of 2015. Still, the evidence is not completed of the complainant. I'm just referring to 2 or 3. Absolutely, my lord, this is a case of the lawyers tried the both parties, my lord. And finally, my lord, the
Both parties.
Both parties, my lord.
You are representing which party?
But I am very fair to this court, my lord. 15 case, 2015, cognizance was taken on 14/9/2015. Now 25, my lord, 10 years. The statute says it must be disposed of within 6 months under section 143. Therefore, my lord, is absolutely a glaring example of lawyers tiring. Cross-examination started. Now, cross-examination was started on, my lord, kindly have a look at page number 28. On 15/11/2017, my lord, the first cross-examination was started.
Page number?
Page number 28, my lord.
Yes.
This we my lord can also cite this example in the training of the judicial officer, my lord. This such a type of cases also in our state. My lordship will find that page 28, the first cross-examination starts. Then, my lord, kindly have a look at page 30. They filed the accused has filed an application for call for a sale tax return, my lord, of 2014-15, 15-16. And that was allowed without our objection, my lord. Oh, lordship is, we all aware, my lord, in NI case, the evidence is the reverse doctrine is applicable. Now they call for a throw us that to be proved, my lord. And that application was allowed. Subsequently, lordship will find at page 30.
How many witnesses are there?
There are only 2 witnesses, my lord. The complainant and another.
At what stage the case is pending?
Now lordship can have a look at that. The first cross-examination was started 15/11, and thereafter he was 3 times he was cross-examined. On 29/7/2023, my lord, he was after 17 he was cross-examined on 29/7/2023. Still in cross-examination. Then, my lord, on 16/5/2025, he was last cross-examined.
And now they file
And they now again
PW, the complainant.
Complainant, my lord.
Cross-examination is
Yes,
continuing.
yes, continue. And my lord, now they again filed an application to
to call for that cell tax return. Again, on 16/7/2025.
What relief you are seeking?
My only prayer, my lord, that the learned lower court must adhere to the statutory provision
Enact some
143 subsection 3
enact.
and all direction by the Honorable Supreme Court. Supreme Court, my lord, is aware in so much to take up the matter of the NI cases for speedy disposal. In spite of all those directions, my lord, this is a case in our state which is pending since last 10 years. And still the cross-examination of the complainant is yet to be completed. My only prayer, my lord, the direction to the learned court below, that to conduct a day-to-day proceeding and dispose the matter. This 143 subsection 3 has been inserted with effect from 15/6/2015, my lord. That is before filing of my case. This statutory violation.
Heard Mr. B. Datta, learned senior counsel assisted by Mr. S. Teka, learned counsel for the petitioner. This application under section 528 of BNSS has been filed. You should have filed under 227.
Yes, madam. I agree.
528 of BNSS. By the petitioner, namely Shri Bijoy Kumar Agarwal, praying for an appropriate direction to the trial court for expeditious disposal of the NI case number 70/2015 pending before the said court. Learned counsel for the petitioner has submitted that the petitioner as complainant had filed a complaint under section 138/142 of the NI Negotiable Instrument Act 1881 against the respondent in the year, when have you filed?
2015.
In the year 2015. However, even after lapse of 10 years since the date of filing, the case is still pending at the stage of cross-examination of CW1, complainant's witness number 1. He further submits that the complainant witness was initially examined by the trial court on 15/11/2017. And thereafter, he was cross-examined after a gap of 6 years on 29/7/2023. He further submits that due to the dilatory tactics and why it is late?
My lord, is initially our part and later on, my lord, they continuously they call for a records, etc., etc.
Learned senior counsel for the petitioner has submitted that in this is a case where there is clear violation of the statutory provision contained in section 143 within bracket 3 of the Negotiable Instrument Act 1881, which mandates that the trial under the trial under the trial for trial under the provision of Negotiable Instrument Act shall be conducted as expeditiously as possible, and all endeavors shall be made to conclude the trial within 6 months of the date from the date of filing of the complaint. However, the trial court has failed to comply with the said provision, said statutory requirement. Stop. I have considered the submissions made by London Council for the petitioner and have gone through the records of the case. It is apparent that the statutory mandate contained in section 143 within bracket 3 of the Negotiable Instrument Act has not been followed. Rather, it has been violated in conduct of the trial of the NI case number 70/2015 pending before the Court of London Judicial Magistrate First Class Tinsukia. So, considering the nature of relief, the petitioner has sought for the relief of, where is the prayer portion? You are pressing for mainly expeditious.
Yes, yes. To page 16, my lord.
Sought for the relief of issuance of direction to the trial court for disposal of the aforesaid case as expeditiously as possible within a specified time frame. Stop. Considering the nature of the case and nature of relief sought for by the petitioner in this case, the notice to respondent is dispensed with, and this criminal petition is disposed of with a direction to the Court of London Judicial Magistrate First Class Tinsukia to dispose of to conduct the trial of NI case number 70/2015 as expeditiously as possible. I'm not giving any time frame.
That's the problem, my lord. Supreme Court says that you cannot, but preferably, but if possible.
No, we will call for a report. We'll dispose this off. A report will be sent to the Registrar General.
Right. That.
क्या लिखा? No, not to dispose of, to conduct the trial of the NI case number as expeditiously as possible.
As mandated under section.
That has been violated. And to dispose of the said case. Though this criminal petition is disposed of, however, the registry of this court is directed to monitor, no, to continue. The trial court, the learned judicial magistrate first class is directed to send a report, send a report regarding compliance of this order to the Registrar General of this court within a period of 45 days from the date of this order.
That will be.
This criminal petition is accordingly disposed of.
So, item 60 from supplementary list.
There's two criminal petition, my lord. This is a complaint petition filed against us. My lord may take up two petition together, my lord, for
60.
60 and 60. 1126 and 1127.
Yes.
We have filed a civil suit, my lord, a title suit at the court of the municipality at Morigao, my lord. Lordship will find at page 17. This petitioner is the plaintiff, and the informed and the complainant of both this matter, my lord, criminal petition, they were arrayed as defendant. Page 17, my lord, I kindly heard.
Yes.
Now, Bhupendra Chaudhary is the this petitioner hearing before you. Arun Chaudhary and this Dhani Chaudhary. Arun Chaudhary is the informant of the criminal petition number 1126, first. And is for declaration and possessory of right of the plaintiff. Now, in counterblast,
You have filed the title
suit, my
suit.
lord, suit.
Okay.
Now, in counterblast, they've filed both this complaint petition, my lord, before the trial court. One filed by Arun Chaudhary and another filed by Adhir Das, my lord. And the interesting part is the cause of action and the timing, the date and timing. They released that I theft some bottle nuts, etc., vegetables, etc. And in both the complaints, my lord will find that the same timing and same date. I am a 69 years old. And therefore, my lord may kindly have a look at that the criminal petition number 1126, lord, you will find the incident of the occurrence as page 47. And another criminal petition, lordship will find at page 41. If lordship compare both these incident is same time, same date, and same allegation. In respect of the same land. In respect of the same land. In first complaint, they have said 80,000 value of this battle nut, etc. I have stolen away. And the second complaint, they have said the 50,000. That's the improbability. Absolutely improbable facts. This is one aspect, my lord. And second aspect, my lord, this is the first time after the BNSS came, my lord, that now the notice has been issued to the prospective accused under section 223 lordship is there. Now, the trial court in our state, my lord, after filing of the complaint, immediately issued the notice. Perhaps that would not be the correct approach. That issue has not been examined till yet. No judgment has been pronounced by the Honorable Court, my lord, of our High Court. So that issue also we would like to
address this honorable court to examine.
What is your submission?
My submission is, my lord, that before issuance of notice, you must take the statement of the complainant and other witnesses. The proviso says, my lord, for issuance of notice. But substantive section says you have to first take up the complainant, then you take the statement, etc. Provided before cognizance, you have to issue notice. But nowadays, what we see, my lord, that the trial court in a CR case, they have issued the notice after received the complaint. My lord, have a look into 223.
223.
Yes, my lord.
Where is that notice issuance?
Lordship will find. Page 52. 21 to, yes. Page 52.
No, statute in the.
Yes. 223, my lord, subsection 1. It starts with examination of complainant, my lord. The prefix of the section is the examination of the complainant.
Yes.
Now, a magistrate having jurisdiction while taking cognizance of an offense on complaint shall examine upon oath the complainant and the witnesses present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses and also by the magistrate. Now, this is a substantive section, my lord. Provided that no cognizance of the offense shall be taken by the magistrate without giving the accused an opportunity to be thought. That will come later on. Once you have the complaint, you have to examine the complaint.
Okay, so under this proviso notices are.
Yeah, then the provision will come.
Your suspicion is that after examining the complainant, if you find that cognizance may be taken, before taking that, notice has to be issued.
But nowadays,
now what is being done?
Now in the entire state, my lord, the notice, even in the NIA, the trial court issued the notice. NIA.
Without examination of the
complainant.
Okay.
NIA cannot. But in other complaint also, stateway issued the notice. That practice has been going on in our state. In some high court says there is difference of opinion. So that legal issue will also be examined, my lord, if lordship deemed it fair.
When is the date fixed?
Next date, my lord. 23 September.
We'll issue notice.
My lord. Further proceeding, my lord. It's absolutely, lordship will find because all the matters before this honorable court.
Not now. Let the respondent appear.
Lordship, I am a 69 years of age, my lord. My lord, kindly have a look. That is it possible for a man of 69, 70 years to commit a crime of a theft in a plot of land of 80,000, my lord, and 50,000 on the same day? If one complaint is lost, my lord, there may be a probability, prima facie. There is two complaints, my lord. And two complaints, same cognizance, same incident, my lord. That's why I'm pressing, my lord. Otherwise, I will not press.
And who are the accused persons? In both the complaints, same accused.
Same accused person, my lord. That's the point. A person, an individual committed a crime of theft in the morning hours at 9 o'clock against those defendants against whom I am filed a civil suit. They allege, my lord, that I have committed two incidents on the same day, on the same time.
Time is?
Time is same, 9 o'clock. I am just reading out.
And land?
Same land, my lord. Let's say page 47 of the first criminal petition, my lord.
Same land, then what is the improbability?
No, same land, they said. Both the complainant says
They separate land, but the adjacent land. They have not said the same land. But in our suit, my lord, we have that is the plot of land.
Mr. B. Datta, learned counsel for the petition, learned senior counsel assisted by Mr. S. Dekar, learned counsel for the petitioners. This application under section 528 of PNSS has been filed by the petitioners, namely Shri Bhupendra Chaudhary and Shri Bishwajit Chaudhary, praying for quashing of the CR case number 144/2025, in which by order dated 21/2/2025, the cognizance of offense under section 303/324 within bracket 4.
No cognizance was taken, my lord.
Cognizance has done. So notices, only notices.
Only notices has been.
Okay.
Without taking cognizance, because before cognizance, notices to be gone, but without examining the complainant,
Yes.
the notice was.
The notice by order dated 21/2/2025. Notices under section 223 of BNSS have been issued to the petitioners in CR case number 144/2025. Learned counsel for the petitioner has submitted, learned senior counsel for the petitioner has submitted that the petitioner number 1 had filed a title suit against the informant before the Court of Learned Civil Judge Junior Division Morigao, which was registered as title suit number 16/2025, where the relief of declaration of right title and interest of the petitioner number 1, as well as for recovery of possession, was spread for. Learned senior counsel for the petitioner has submitted that the complaint filed by the respondent number 1. No, complaint filed by the respondent by the sole respondent is a counterblast against the civil suit filed by the petitioner number 1 against him. Stop. He also submit that at the same time and date, another complaint case, namely CR case number
143.
143/2025
On the same day, both the complaint petition was filed.
has also been filed by whom? This was filed by
Odhir Das.
one Adhir Das. He submits that the acquisition in both the complaints are different.
Same, my lord.
Acquisition are both the
Timing, date.
complaint are same. Are similar. Similar. As in one case, as in the present case, the allegation is of committing theft of betel nuts.
In other vegetables, my lord.
And other and damaging the other valuable trees and in the said land, and the quantum of loss has been assessed by the has been approximately stated in the complaint petition to be in the tune of rupees 80,000. Whereas in the another complaint with similar accusation, the quantum of loss has been stated to be rupees 50,000, which learned senior counsel submits that is highly improbable. Let the notice be issued. The petitioner shall take steps for issuance of notice upon the respondents by registered post with ID as well as by usual mode within 3 days from the date of this order, returnable on, yes, Putul, return 16th of October. Considering the submissions made by learned counsel for the learned senior counsel for the petitioner as discussed in the foregoing paragraphs, further proceedings of CR case number
144. It's Arun Chaudhary case, my lord.
open, it is CR case number 144/2025 shall remain stayed till the next returnable date. List accordingly. The other case is similar.
Similar 143 on the CR case.
Next item is similar, some changes will be there. I'll dictate.
Grateful. I think 62.
May please, Your Lord. My lord, the application under Part 28 of the BNSS for paying for my lord quashing of the FIR. And
Quashing of the
consequent FIR, consequent charge sheet, my lord, and the further proceedings. My lord, what has happened? The petitioner, my lord, he is a, my lord, in fact, director, one of the directors of a private limited company, High-Rise Infratech Private Limited. Now, FIR, my lord, which is the type copy, which is at page 15. I take your lordship's, my lord, to the vernacular, which starts from 16.
When is the date fixed?
In fact, the next date is 19/9. My lord, what has happened? The informant, he says that certain articles were lifted by the company.
Where is the FIR?
FIR, my lord, the relevant part is page 18. And on the next, my lord, part, he proceeds to say that against the service rendered, my lord, the payment has not been received. Now, the allegation is not clear as to whether his grievance is in respect of the articles or, my lord, the service rendered by the farm, my lord, that is farm Bagri Telecom and B Road, Tejpur. Now, in the entire, my lord, FIR, he does not indicate regarding, my lord, any invoice, bill, money receipt, nothing. And subsequent thereto, if your lordship comes to the charge sheet, my lord, which starts from page 27, the investigating officers, my lord, reaches the conclusion that the offense under 420 and 406, my lord, is are committed, the relevant part, page 32, on the basis of two documents. One is, my lord, the sketch map, and the other is, my lord, police bail bond. My lord, these are case of documentary evidences, and the police has reached, my lord, the conclusion that 420 and 406, my lord, is made out on the basis of sketch map, my lord, and police bail bond. And the witnesses, my lord, which are examined are some police officials and the informant himself. Now, subsequent there to what had happened, this company had gone under liquidation, my lord. And the liquidation order, your lordship will find, which starts at page 33. My lord, this is the order of the NCLT, and the name of the, my lord, present, my lord, company is reflected, my lord, as corporate debtor at page 33, MS High-Rise Infratech Private Limited. And the order of the NCLT is of, my lord, 21. 7/12/21. And the relevant part, page 36, my lord, para 10. This tribunal in the circumstances, taking into consideration the provisions of law as well as facts, is constrained to order of liquidation of the corporate debtor. And the circumstances, the corporate debtor stands liquidated and the incidence of liquidation to follow on and from the date of this order in terms of provisions of IBC 16 and more particularly so and so, and also in terms of insolvency, bankruptcy, along with the following directions. So there are directions, my lord, of the liquidation of the company, and page 38, which is relevant also, my lord, the clause F. This order is deemed to be a notice of discharge to the officers, employees and workmen of the corporate debtor as per section so and so of the IBC code. So by this time, my lord, the director is also non-functional. Now, my lord, my respectful submission is, at best, my lord, it's a case of breach of contract. And the Honorable Supreme Court, my lord, has held that every breach of contract, my lord, does not carry with it, my lord, the element of, my lord, criminal offense. And more particularly, on the basis of the allegations level, my lord, no offense under 420 or 406 is made out. So Bhajanlal, my lord, clearly applies in this present case. And in respect of, my lord, 406, my lord, a recent judgment of the Supreme Court, I rely on para 7. If your lordship comes to para 7, my lord, it's criminal appeal of 2024. Yes, my lord, I take your lordship directly to para 7. Essentially, the present dispute between the parties relates to a breach of contract. A mere breach of contract by one of the parties would not attract prosecution for criminal offense in every case, as held by this court in so and so. Similarly, dealing with the distinction between the offense of cheating and a bare breach of contractual obligations, this court in so and so has held that every breach of contract would not give rise to the offense of cheating, and it is required to be shown that the accused had fraudulent or dishonest intention at the time of making the promise. Now, from the reading from the FIR as well as charge sheet, it does not, my lord, disclose that there was some element of cheating. And at best, my lord, it's a breach of contract. The petitioner, the informant has a remedy, my lord, alternative remedy, my lord, to have the money, to get the money if there is any due, my lord. So my respectful submission, it's a case of pure, my lord, civil nature. And therefore, the continuation of the proceedings, my lord, in my respectful submission, would be an abuse of the process of court. And on the basis of the material, even accepting, my lord, that there are, my lord, even the uncontroverted allegations, if it is accepted to be true, it does not make out any offense under 406, 420. Therefore, the Bhajanlal comes into play, my lord. And it's a fit case, my lord, for quashing of the FIR and the consequent charge sheet. This is my humble submission.
Heard Mr. S.K. Talukdar, S.P. S.K. Talukdar, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner, namely Gauri Kumar Pachani, praying for quashing of the affair and the charge sheet number and the resultant charge sheet number 54/2024, which was laid in PRC case number 421/2024 before the Court of London Chief Judicial Magistrate, Sonitpur. The gist of accusation in this case is that on 23/12/2023, one Sushil Kumar Bagri had lodged an FIR before the Superintendent of Police, Tejpur, inter alia alleging that the present petitioner and one other person, namely Tirthanath Das of High Rise Infrastructure Infratech Private Limited took some articles from the proprietorial firm of the informant amounting to rupees 14,08,185. However, it is alleged that they have not paid back the what
It says, my lord, that আমার কাম করা বিনিময়ত কোনো টাকা আজ পর্যন্ত দিয়া নাই।
paid back
For the service rendered.
anything in respect of the service rendered by the firm of the informant. The allegation of misappropriation of the said amount has been made in the FIR. Stop. Learned counsel for the petitioner has submitted that the FIR does not disclose any criminal offense against the present petitioner. He further submits that even if the FIR is taken on its face value, it would only reveal that the allegations of breach of contract has been made against the present petitioner. He submits that no ingredient of section 420 or section 406 of IPC has been made out against the present petitioner. He further submits that even in the charge sheet, the investigating officer has not indicated any material from which the existence of ingredient of section 420/406 of IPC may be made out. He further submits that in the meanwhile, before filing of the FIR, the firm,
Private limited company.
the private limited company, namely High Rise Infra Tech Private Limited, of which the petitioner was a director,
My lord, director.
has already been liquidated by the order of
National Law Company Law Tribunal.
National Company Law Tribunal by the order dated
Page, my lord, 33,
order dated
7/12/21.
7/12/21 passed in IA number 5533/2021 in company petition number within bracket IB dash 1718 within bracket ND/2019. The said company has been liquidated and the office bearer and employees of the said company, which is regarded as a corporate debtor under section regarded as corporate debtor have been discharged. Thus, what is your submission? He no longer remains.
No,
as-
he no longer remains director because he has been discharged by the.
Thus, after the said,
Non-functional.
thus, learned counsel for the petitioner submits that after the said order, the said order of National
NCLT, my lord.
and of NCLT, the petitioner no longer remains the director of the Infratech.
High-rise Infratech
High-rise Infratech Private Limited. And the counsel for the petitioner has also submitted that the FIR only indicated regarding the allegation of breach of contract against the present petitioner and the Hierarchy Infratech Private Limited Company. However, every breach of contract would not give rise to the offense of cheating unless there are materials to show that the petitioner had fraudulent or dishonest intention at the time of making promise. And nothing of that sort could be shown by the investigating officer. In support of his submission, the petitioner, learned counsel for the petitioner, has cited a ruling of the apex court in the case of Naresh Kumar and another versus State of Karnataka and another, within bracket, order dated in 12/3/2024 in SLP within bracket criminal number 1570/2021. Learned counsel for the petitioner has submitted that the trial court has already issued summons to the petitioner, and next date
19/9.
has been fixed on 19/9. He also submits that since the dispute between the parties are predominantly of civil nature, continuation of the criminal proceeding against the petitioner would be an abuse of the process of court. Hence, he prays for quashing of the said charge, quashing of the proceeding of the said case. Issue notice to the respondent. Since Mr. K.K. Parashar has appeared for respondent number 1, no formal notice need to be issued to the said respondent. As against respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon the said respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 15th of October 2020. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, further proceeding of PRC case number 421/2024 shall remain stayed till the next returnable date.
Pending before CJM, Sonitpur TH4.
Yes, that I have mentioned.
Like, can copy.
Yes, before that, let the scan copy of the trial court records as well as connected case diary, scan copy of the connected case diary be called for.
Deeply obliged.
Here, my lord. I straightway take my lord to page 30, my lord. Page 30. Here the petitioners were granted interim pre-arrest bail, my lord.
Interim?
Interim pre-arrest bail, my lord. In a different case, your lordship. Page 30. They were granted, my lord, pre-arrest bail, my lord. Interim pre-arrest bail. With certain conditions, my lord.
Yes.
Now, my lord, now, but Lordship, one of the condition is that, they should appear before the concerned police station within 7 days, my lord. Now, my lord, Lordship may kindly see, now, my lord, now threatening has been given, my lord, that if we go there, my lord, then on similar grounds, my lord, on similar circumstances, they will lose another case, or they might have lost another.
You don't know about the.
No, my lord, no, my lord, here, my lord. So, my lord, if I go there, because, my lord, there are, my lord.
Who has threatened you?
My lord, my lord, the earlier informant, my lord, a very influential person, my lord, he is the owner of a big company, my lord. So he has other small companies under him, my lord. So on similar situations, Lordship may kindly turn to page 30, paragraph 3, my lord. On similar grounds, my lord, my lord, another case might have been lost against me, or, my lord, if I appear, my lord, if my whole family is there, my lord.
But that was Golaghat PS case number 162 of 25, page 30.
Yes, my lord.
Now, my lord, he is appearing that in Soru Pothar, Bor Pothar.
Under the Golaghat district, my lord.
Golaghat.
Because my lord, I was the head accountant, my lord.
No, what is the basis of your apprehension? Suppose you apprehend that all over Assam.
No, not all over Assam. Only the informant where he has companies, my lord. Now, my lord, the allegation is that I was the head
So
accountant.
we have to call for a report.
My lord, Lordship may call for a report, my lord, and, my lord, if possible, my lord, Lordship may, my lord, give a direction that if similar cases are there, my lord, I may be protected, or, my lord, because I will have to appear within 7 days, my lord. Right.
No, the case in which you have to appear, you already have the protection.
My lord, that I have protection, but, my lord.
And the case which you are apprehending may not have been filed. You don't know.
May not have been filed, my lord.
May not be in existence. So unless we call for a report.
So, my Lordship may record by submission only, my lord, and call for a hearing.
Okay.
My lord, a report can it be tomorrow? Telephonic report, my lord, he can obtain tomorrow, because tomorrow is my last date. For 7 days will expire tomorrow. From the SP office, he can. My lord.
Yes, Mr.
From the 4 PS, my lord, they have given, my lord, Soru Pothar, Bor Pothar, Golaghat, and Dergaon.
All Golaghat district, my lord.
All Golaghat district, but we have to call all the OCs, my lord. I'll take.
Okay, let him find out.
Tomorrow.
We'll fix it tomorrow.
Tomorrow.
Heard Mr. S.M. Abdullah P. Learned counsel for the petitioner. Also heard Mr. K.K. Para, learned counsel for the petitioners. Namely 1, 2, 3, 4. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner has obtained an anticipatory bail from a coordinate bench of this court on 5/9/2025 in connection with Golaghat PS case number 162/2025 under section 61 within bracket 2/318 within bracket 2/316 within bracket 4/336 within bracket 3 of BNS. He submit that one of the conditions on which he was granted interim anticipatory bail in the aforesaid case is to appear before the trial court within
Before the investigating IO.
Before the investigating officer within
7 days.
7 days. Learned counsel for the petitioner submits that the 7 days granted by the coordinate bench of this court would lapse on
Day after tomorrow, no?
would lapse on
5/9 months.
11
months.
12/9.
12/9.
12/9. However, he submits that he has received from who is threatening you?
But the informant, he stops, my lord.
Where is that statement?
Okay.
Who is the informant?
Page 10, paragraph 11.
You have not made in,
No, here, there may be other informants, because there are a number of companies,
no, who is that informant?
but earlier informant, now, document kindly see that.
What is his name?
Document kindly see that, this one put there. This different company, this one. Page 5, paragraph 4, Here, here, there are a number of companies where I was accountant. So anyone, because on similar grounds, because page 5, paragraph 4.
Who is the informant?
But any one of this might have lost, because
No, you are not answering my question.
my lord.
In the earlier case, page 17.
You don't know the name of the informant.
One Gautam. Petidora Gautam. Page 17.
No, where is your apprehension? Who may lodge a FIR against?
Page 10, paragraph 4. Page 10,
No,
paragraph
I
11.
am asking a question,
My lord.
not page numbers.
Repetition
Who is threatening you?
Actually, there are 11 companies, 11 companies where I was, 18 companies where I was an accountant, Now, in that FIR, the allegation is that I have misappropriated, company's funds from the company, Now, one company I have granted bail, but similar, the owner of the company, main owner is, one person. So he might have, given direction to the other persons, other.
No, who is the owner that?
Yes, I have categorically stated the other companies, Any one of them,
No, you have either not understood or I am not able to.
Who is the main?
Who is the
Who is the main?
person who is?
Then one company, Tasangpul, group of companies. Lot of right, Tasangpul, group of companies might lose that group, Tasangpul,
No, then this apprehension does not have any basis.
No,
You are yourself not sure about.
No, Tasang, I have categorically stated, paragraph, page 5, paragraph 4. Is owned by I'm not able to name, but page 5, he is a sitting MLA,
You have not named him.
But I have stated his status,
Para 3, they have mentioned, para page 4.
He has received
Vishwajit Pukon MLA, they have mentioned.
threatening threat that if he appears before the investigating officer of Golaghat PS case number 162/2025, some more cases may be filed against him in either in Sorupothar police station, Borpothar police station, Golaghat police station, or Dergaon police station. And therefore, he is apprehensive that in event he appear before the investigating officer of Golaghat PS case number 162/2025, he may be arrested in connection with other cases which might have been lodged against him. So, as the petitioner is unable to inform this court regarding pendency of any other criminal case apart from the one in which he had already been granted interim protection, learned additional public prosecutor is requested to get information from the aforesaid from the officer in charge of efforts at 4 police stations as to whether any criminal case apart from Golaghat PS case number 162/2025 is pending against the present petitioner. The information may be taken telephonically from the officer in charge of. Okay, that is last line cutting. Let this case be listed tomorrow. That is on 11th of September.
In motion column, madam. Because
No, why motion?
normally it comes in motion column, it's not. You put this motion.
Okay.
Apply, chala.
After that, we'll try to take written
May I please your lordship. Well, the FIR was registered under section 64 of BNA and section 6 of POCSO. And subsequently, charge sheet was submitted and charge also framed under the same section. That is 64 BNS and 6 of POCSO. Now,
Anybody is appearing for the Amicus?
But,
Respondent number 2.
It's taken long way back, lordship, in the month of August probably.
July, we have taken the step. Amicus may be appointed here, otherwise for that ground is going to be here. The scan copy has.
Have you taken steps or not?
Yes, ma'am, we have taken steps. We have taken steps on 3007, July month. And he is in jail since 296 days. About a year.
Heard Mr. Enuddin Learned Counsel for the petitioner. Also heard Mr. B. Sharma, Learned Additional Public Prosecutor. Now you take fresh steps.
But once we have taken. So Amicus may be appointed such type of case because. may
You
not be
can take
served.
information. Let him take information whether notice has been.
Then at 2 PM.
No, at 2. You ask him, when can you take?
Well, again, matter will list,
We'll
that
take
day
the
we can still
instruction.
appoint, another day again, case will be here.
Okay, we'll take it up in the second half. You take information whether the notice has been served or not. We'll take it up in the
I'm
next.
35.
There is an office note, lordship.
Yeah, please, your lordship. My lord, this is charge-sheeted case, my lord. The prosecution, my lord, examined as many as 8 numbers of prosecution witness, my lord, out of 9. And one is remain. My lord, the petitioner is, both the petitioner are, my lord, behind the bar since, my lord,
This POCSO case,
20.
Yes.
what
Yes,
is the
my lord.
offense?
Offense is, my lord, under section 6 of POCSO.
Gang rape is there. Lordship will kindly see the office note.
This is
Office
the
note.
second. Yes,
There is an office note.
second occasion, my lord, for the second copy of the case.
When have you taken steps?
No, lordship,
Already
respondent
scan
is-
copy.
name is showing, lordship.
Oh, council has appeared,
Yes,
someone has
their
appeared.
name is shown, lordship.
Who is that?
E. Ahmed and Miss R. A. Chaudhary. Whether the record
Last
has been-
occasion, my lord,
We'll take it after some time. Oh, Putul. Mobile number আছে না? Wakalat number. Phone call. We are informing the
Lordship.
E. Ahmed, respondent number 2, council, E. Ahmed. And let us find out.
Take you on the second half, lordship. In the meantime, I'll go through the record.
Second half, in the second half,
I can also inform him.
if you inform, it would be good. You know the who is R. A. Chaudhary?
I know.
Okay. R.A. Chaudhary is Roshan Ara Chaudhary.
No, my lord. There is
Okay.
another. Obliged.
Your Lordship, case diary not received.
Heard Miss, what is your name? Debashri Chakravarti, London. Yes,
Lordship, you was on interim lordship.
And that interim bail was rejected by the lower court lordship. The petitioner is 131 days is in custody. And this driver before, and this petitioner before lordship
let
is
the
a
case diary come. It is a
NDP.
commercial quantity. Case involving commercial quantity. Also heard Miss M. Deka, London, counsel for NCB, who prays for some more time for producing the case diary. The prayer is allowed when. Let this matter be listed on 23rd of September
Custom lordship and NCB is not the part.
instead of NCB Customs Department.
Wait, please, your lordship. Lordship, let this matter come up before vacation, lordship. Today I have taken the state lordship from the respondent.
POCSO.
POCSO 4/6 is there.
They were directed to take steps, lordship, on 21/8/25 and office note dated 8/9/25.
Then it will go after vacation.
That will be after vacation.
Today, lordship, I have taken lordship, is keep my notice, lordship. That's why lordship LCR is already there, lordship. And moreover, he is 11 months in jail custody, lordship.
Heard Mr. B. Chaudhary, London counsel for the petitioner. Also heard Mr. B. Sharma, London additional public prosecutor. It appears from record that the petitioner was directed to take steps for issuance of notice upon respondent number 2 on 21/8/2025. However, office note shows that no steps was taken by the petitioner. Stop. Learned counsel for the petitioner has submitted that the petitioner has taken the steps for issuance of notice upon respondent number 2 today only, and therefore prays for listing this case after
Before vacation, lordship.
Before that, let this matter be listed again on 26th of September.
Highly obliged.
38 lordship, charge sheet has been submitted.
Heard Mr.
Mohammed A. Rahman.
Mohammed A. Rahman, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number
129/25 dated 31/8/25.
As the charge sheet has already been submitted in this case, this bail application is disposed of with an observation that the petitioner may approach the trial court and may file an application for regular bail before the said court, if so advised.
Highly obliged.
49. Lordship, the office note 8/9/25 suggested service report is still awaited, lordship.
Service is awaited. POCSO matter.
POCSO matter, lordship.
You are appearing.
Procedural matter, my lord. The informant and as well as the victim is already been examined by the trial court, and they have stated nothing against the accused person.
Where is the
Lordship, may kindly see the answer 5, page 70.
page?
Page 70, my lord. PW1. Is the informant as well as the father of the victim.
Where is the victim?
Victim is PW2, my lord.
Lordship, turn on to page 72, my lord.
What is your name?
Krishna Borua, I am Zakir Hussain, my lord.
Zakir Hussain. Only one petitioner is there.
Zakir Kodani, my lord, yes, already. He is a sole
Zakir
elected person.
Hussain.
He is also a deaf and dumb person, my lord, 100% disability, suffering from hearing impairment, as well as he could not speak, my lord.
Okay. Who cannot speak?
Accused person, my lord.
Accused is defender.
Defender, my lord. Medical board, there is a report of medical board, my lord.
What the PW2 has.
There is misunderstanding, my lord. Because the accused petitioner could not speak, he used to use sign language if you want to speak, communicate to someone, my lord.
The victim was declared as hostile.
My lord. And even my lord, 164 statement, the section recorded under section 183 of the DNSS, he did not speak about any sexual intent, my lord.
Okay. Since when you are behind the bars?
My lord, 77 days than today.
77 days.
77 days.
Yes.
Lordship, I did not go through the records, Lordship, on account of the office.
No, you go through, okay, there may be other materials.
I could not go through.
Yes,
I have enforced all
what
the
is your
documents,
submission?
charge sheet.
Comment is fine, hostile background.
You are engaged counsel or legal aid counsel? What are your instructions?
Pardon your lordship. In earlier occasion, lordship, I kindly see page 84. In earlier occasion, when the petitioner move for bail
You
application.
don't have any instructions from your,
Have instructions to object. And
to object the bail. Then let additional public prosecutor go through the record. We'll take it up
For a moment, my lord.
next half, second half.
Okay. They have stated, they have raised no objection in earlier occasion, man. And it is reflected in the.
PW1 and PW2 have not stated anything. You find out if we'll take it up in the second half.
Not.
Heard Mr. I. Hussain, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this case be listed on
23rd,
23rd of
September.
23rd of September. For reasons mentioned in the judgment, this criminal petition is dismissed.
Sorry.
Particular lordship, I've taken the instruction, service is complete lordship, they had sent the form lordship to the registry lordship.
Form to the
Acknowledgement lordship, where the respondent has signed lordship. Regarding service of notice lordship. That receipt copy has been sent to the registry.
but it has been served.
Yes, it has been served.
Then we will, who is appearing for the petitioner?
It's not here. Amicus may be appointed. He also made the same prayer.
Okay. Heard Mr. N. Uddin, learned counsel for the petitioner. Also heard item number 34.
34.
Sorry. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that he has been informed by the officer in charge of jurisdictional police station that the notice issued to respondent number 2 has been duly served. Since no one has appeared for respondent number 2, this court intends to appoint one amicus curiae. Any amicus curiae is present in the court. Amicus curiae to defend the cause of respondent number 2 in this case. Accordingly, Mr. You are there. Accordingly, Mr. A. Ahmed, London counsel whose name appears in the list of amicus curiae in the prepared by the registry, is hereby appointed as amicus curiae to defend the cause of respondent number 2 in this case. The petitioner is directed to serve a copy of bail application along with the annexures to the newly appointed amicus curiae. The registry is directed to reflect the name of Mr. A. Ahmed in the cause list as amicus curiae for respondent number 2. Please this matter. Before vacation?
Yes.
Before week, 25th of September. ফোন করেছিলেন?
May I please, Your Lord?
You are appearing for the. Okay. Yes.
Lord, there are, my lord, 10 prosecution witness, my lord. Lord, out of nine prosecution witness, out of 9, my lord, 8 has already been examined, my lord, including the informant, victim, and 1 is left. Oh, my lord, they are, my lord, in jail from 27/4/2023, my lord. 2 years, 5 months, my lord. Behind the bar.
What is the accusation?
My lord, the section 6 of POCSO Act. FIR at case, my lord. 16, Arnicle. Lord, only, my lord, that's when, my lord, the 1 witness is, my lord, yet to be examined. And 9
No, what is your case?
Yes, is, my lord.
Apart from long detention,
Yes, my.
only long detention, nothing else.
And my lord, last 1 year, perhaps last 1 year, no witness, my lord, turn up to that door.
Yes.
Lordship, yes, then first Lordship will be open.
Yes.
Whatever there it is there in the report, I have deposed everything in before a learned court.
You have filed any objection?
No.
What is your stand?
Depose everything, whatever that is known to me and in the before the honorable court. That is in the page number 34.
You don't have any objection if the petitioner is. No, ultimately everything will be left for me, but I want to know your order shall have to be passed by me only. But what is your stand? Do you have any objection? You have not been instructed. Okay, okay. Yes, Mr. Sharma.
Yes, here Lordship, from the records I have seen Lordship, already the case is fixed for statement of defense.
SD.
Yes, and I'm just trying to bring few facts before your Lordship. On Lordship 11/7/25, PWs was closed. Prosecution witnesses was closed, Lordship, on 11/7/25. And the next date was fixed for statement of defense. Then Lordship, on the next date, when it was fixed for defense, Lordship, a statement of defense, on 8/8/25, they filed a petition for re-examination of PW 1, 2, 3, 4, and 5.
Re-examination.
Re-examination. They filed a petition, Lordship.
And
thereafter,
was it
Lordship,
allowed?
No, Lordship. Thereafter, the date was fixed on 22/8/25 for necessary order on that petition. What happened on 22/8/25 is not before your Lordship. That apart, there are a few more things, Lordship, I'll have to.
On what ground you are seeking
Not
re-examination?
on wrong tension, my lord.
No, no.
Yes.
Why are you seeking re-examination of 1, 2, 3, and 4? Yes, Mr. Shan.
Thereafter,
Being
Lordship.
disposal of this petition, my lord, perhaps it is going on.
That apart, if Lordship kindly comes to page 54. This is the earlier bill application which was rejected by the coordinate bench, Lordship. Here, Lordship, why it is important, Lordship, if Lordship kindly comes to paragraph 6, page 56.
Page number?
56.
Yes.
Yes, Lordship, paragraph number 6, Lordship, you kindly see. On perusal of the records of the case, it is seen that the petitioner preferred criminal petition number 1267/23 as the learned special judge POCSO Borpeta by an order dated 18/11/23 rejected the petition filed by the petitioner under 311 CRPC. Later on 23/24, a coordinate bench of this court in said criminal petition referred by the petitioner have stayed the further proceeding of the so-and-so, so-and-so, so-and-so. Thereafter, Lordship will see paragraph number 7. The petitioner in this bail application filed on 1/10/24 did not state that they preferred criminal petition so-and-so, in which the court on 23/24 passed an interim order staying the further proceeding of the said POCSO case number so-and-so pending in the court of learned special judge POCSO come additional session judge Borpeta. Thereby, the trial of the said proceeding has been stayed. Rather, they stated that they are in custody from the date of their arrest on so-and-so and so-and-so. Paragraph number 8, Lordship, for such suppression of facts, both the petitioners are directed to deposit exemplary cost of 10,000 each within this so-and-so. So, Lordship, the delay part and paragraph 9 also, Lordship, as the petitioner have suppressed the fact of filing of said criminal petition so-and-so, when there is an interim order staying the further proceeding of the POCSO case, the bail application stand dismissed. So, Lordship, the delay part, Lordship, is not tenable, Lordship. And altogether, Lordship, here statement of defense has already been fixed. Thereafter, they are again trying to prolong the case. And what happened on 8/8/25 is not clear also.
And what is the deposition of the victim?
Yes, I have gone to the deposition also, Lordship. It was recorded on 21/8, no, Lordship. PW6 is the victim. PW6 is the victim.
Yes,
Her date of birth is 23/1/2009. Page 41. Yes. It is similar to the 164 also, Lordship, as well as the 161 also. She has clearly implicated the present petitioner.
The trial would be over. It is.
Yes, ma'am. Only on the detention, my lord. Let them remain some days, my lord, in the outside.
For what purpose? Because your presence is not necessary for defending the case. The trial is almost over. Heard Mr. S.A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Ms. R.A. Chaudhary, learned counsel for respondent number 2. This application for bail under section 483 of BNSS has been filed by the petitioners, namely Shri Biplab Mandal and Shri Bhumidhar Sarkar, who have been detained behind the bars since 27/4/2023 in connection with special POCSO case number 129/2023. Under section 376 within bracket DA IPC of IPC, read with section 6 of the POCSO Act. The gist of accusation in this case is that both the petitioners are facing trial before the Court of London, Special Judge POCSO Borpeta for under section 376 DA of IPC slash IPC read with section 6 of the POCSO Act for committing gang rape on the victim girl on whether name of Mr. D. Gogoi has been reflected. Item number? What has happened to? We'll list it on Monday. Monday or Tuesday. Heard, Mr. What is your name?
Yes.
A.
Hussain.
A. Hussain, learned counsel for the petitioner. Also heard, stop. None has appeared for the respondent side, though the name of Mr. D. Gogoi, learned Special Public Prosecutor Wildlife, has been reflected in the cause list. It also appears that by order dated 1/9/2025, Mr. D. Gogoi had sought for a week's time to take necessary instructions and production of preliminary offense report in connection with this case. Stop. In view of above, let this case be listed again on 15/9. 15/9. Yes, number of cases. Okay, 15/9, Monday.
42.
CD has not been received.
Some fallback may be given for the CD law.
Heard Mr. R. Sharma, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for production of the case diary. Prayer is allowed. Let this matter be listed on 23rd of September.
15, 16.
19th.
Mayor President, is a regular bail application, Lordship. As on today, 32 days in custody, Lordship. During the custody, 2 days police custody, Lordship. And case is registered under section 319, where is the punishment is prescribed only for 5 years, Lordship. And another section, Lordship, 79 of BNS, Lordship. This also only for 3 years, Lordship. And another section, Lordship, 67 of IT Act, Lordship. It was prescribed for only for 5 years, Lordship. So considering the length of detention, Lordship, and also the police truly interrogated 2 days police custody during. So further custody detention is not required, Lordship.
Case diary is there?
Yes, Lordship.
Yes.
Here, Lordship will kindly come to the forwarding, page 15. In short, Lordship, these two petitioner Lordship, they have circulated one obscene photograph of the informant Lordship. That is the basic allegation. And how it came to the finding Lordship will find at grounds of arrest, point number 1, at page 15.
How many petitioners are there?
Two
Two.
petitioners.
One is lady.
It also Lordship, that they have 47 and 48 complied, but 36 is not complied by.
What is the progress of the investigation?
Lordship, the photograph.
It was circulated through device Lordship, that was seized by the police Lordship.
Yes. Apart from that, Lordship, more or less substantial progress has been made.
Heard Mr. U. Borgohain. U.S. Borgohain, learned counsel for the petitioner. Also heard Mr. B. Sharma, done an additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioners, namely Birju Singh and Priya Dev Gohai, who are detained behind the bars since 9/8/2025, within bracket for last 32 days in connection with
Morioni PS.
Morioni PS case number 112/2025 under section 319 within bracket 2/79 of BNS, read with section 67 of the Information Technology Act. Learned counsel for the petitioners has submitted that for the offense involved in this case, maximum punishment prescribed is imprisonment for
5 years.
5 years only. Whereas the petitioners have already undergone detention for 32 days. He submits that considering the period of detention, which may be sufficient for progress of the investigation, the petitioners may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Morini PS case number 112/2025 and has submitted that the investigation, though there are materials showing the complicity of the petitioners in the offense alleged in the FIR, however, he fairly submits that the investigation has fairly progressed. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary of Morini PS case number 112/2025. Considering the progress made in the investigation as well as period of detention already undergone, this court is of considered opinion that further custodial detention of the petitioners may not be necessary for fair completion of the investigation if the petitioners cooperate in the investigation. In view of above, the above named petitioners are allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate. Tinisukia.
No,
Which
Tita
court?
Board, Lordship. Sub-divisional judicial
Oh,
magistrate,
oh,
Tita
oh.
Board.
Sub-divisional Judicial Magistrate.
Tita Board.
Tita Board. With following conditions, number 1 and number 2. Send back the case diary. This bail application is accordingly disposed of.
Deeply obliged.
44. Your Lordship, the CD has not been received.
It legal lordship, the case that was called for on the 483 bail application, not received. My lord, I am the 34 days behind the war, my lord.
What is the offense?
Offense is, my lord, illegal money transaction, my lord. FIR is in page 11, my lord.
Okay, okay. Case diary would be required.
My
We are
lord,
giving a
already
short date.
all the name accused person have been released on bail, my lord. Even my lord, who was arrested along with this petitioner, he has been also released on bail, my lord.
What is your submission, Mr. Sharma?
My lord,
Let
already
it be on 19th, Lordship, I will produce the case diary.
Yes,
35 days behind.
Next week, Lordship, Friday, I will produce the case diary.
one more chance. Heard Mr. B. Buragohai, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for production of the case diary. Prayer is allowed. Let this case be listed on 19th of September.
Obliged, thank you.
45 Lordship, CD is available. I am praying Lordship just after a few minutes, Lordship. CD is available, Lordship.
After something.
Wait, with your lordship. Lordship, this is a regular bail application, lordship, 54 days in jail, lordship. Otherwise, statutory period is 60 days, lordship. Similar to the item number 43, lordship. Here, lordship, AI generated photographs were circulated through one Chayanika Das, lordship. Page 19 is the FIR, lordship. Now, lordship, forwarding report that is on 24, lordship. As per FIR, lordship, it is received through Chayanika Das, lordship. I am not for that, lordship. And moreover, lordship, all the offense, lordship, below 7 years, lordship. Now, 35(3) notice was not issued to this petitioner's, lordship, before arrest, lordship. My humble submission, lordship, considering the length of detention, 54 days.
Yes, Mr. Sharma.
Photo was generated, Lordship.
AI generated.
AI generated, and probably it was done by one who accused, Lordship. It was forwarded to this petitioner, he again forwarded to some other person. That is the basic issue.
Okay, heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely. In this case, notice was not issued. POCSO is involved.
Yes, POCSO is there.
Also involved, but lordship, notice was not.
14(1) of POCSO.
Notice ought to have been issued.
Because lordship is a AI generated photographs.
No, what
But
offenses?
54 days.
14(1) of POCSO is there, Lordship. Yes. POCSO is there, Lordship.
But that POCSO, lordship, 14A probably will not come, lordship. Because there say lordship, child is used, lordship. Here child was not used, only the lordship, the AI generated photographs was there.
No, you generated using the face of the child.
Face, but it is AI generated, lordship. not
Maybe.
the- But the section 14 say lordship, it's a child use, lordship. May I take
It's
the
not
14?
about 14, Lordship. The POCSO Act has to be taken as a whole. Whenever a POCSO offense is involved, the victim has to be heard, Lordship.
Yes. Notice has to go.
Yes, at least notice has to go.
What is the punishment?
Punishment, lordship, yes, below lordship, 7 years, in all the cases, lordship. May I read, lordship? Whoever, 14(1), lordship, whoever use a child or children for pornographic purpose shall be punished with imprisonment of either description, which may extend to 5 years, shall also be liable to fine. And in the event of second or subsequent conviction with the imprisonment of either description for a term, which may extend to 7 years. or
We are,
liable to-
we are issuing notice and fixing a short date.
Already,
You
lordship. 54 days, lordship, statutory
Maybe
period is
you-
60, but 35(3) notice was not issued, lordship, case diary is there, lordship.
Heard
Before-
Mr. B. Chaudhary, learned counsel for the petition. Or we may do one thing. We may appoint one amicus
Yes.
instead of issuing. Heard Mr. B. Chaudhary, learned counsel for the petitioners. Also heard Mr. N. Das, learned. Also heard Mr. B. Sharma, learned additional public prosecutor. It appears that though this case involves offense under POCSO Act, no notice to the respondent number 2 was issued. Stop. Learned counsel for the petitioner, on the other hand, submits that the maximum period for which the petitioners may be detained behind the bars during the period of investigation is 60 days, considering the offenses involved in this case. So he submits that the petitioners have already completed 54 days behind the bars and therefore prays for a short date. Prays for releasing the petitioners on bail. Stop. I have considered the submissions made by learned counsel for both sides. Considering the facts of this case, this court is inclined to appoint one amicus curiae to defend the cause of the respondent number 2 in this case. Any amicus in the court? Mr. Laskar? Yes. Accordingly, Mr. What are your initials? M.H. Laskar is hereby appointed as amicus curiae to defend the cause of petitioner in this case. Defend the cause of respondent number 2 in this case. The petitioner is directed to furnish a copy of bail application along with the annexures to the
Today itself, Lordship,
respondent to the newly appointed amicus curiae during the course of the day. The registry is directed to reflect the name of Mr. M.H. Laskar in the cause list as amicus curiae for respondent number 2. Let this case be listed on 17th of September.
Can it be on Lordship Monday, Lordship? Because only because the service of the amicus curiae is there, Lordship, and serve the copy today, Lordship.
Our list, Monday is possible. Will Monday be okay for you? On 11, on 15th.
Obviously.
48.
The FIR is at page 12, Malad. Petitioner is behind the bar since last 43 days, Malad. Allegation is that, Malad, he has forged the signature and manufactured a work order, hack work order. May I read the FIR, Malad?
Yes.
With reference to the subject cited above, I have the honor to inform you that
Page number?
Page number 12, Malad.
Okay. Yes.
With reference to the subject cited above, I have the honor to inform you that about the following facts and request to kindly to so and so. That sir, on 16/6/2025 at about 4 p.m., one Sri Mriganko Dotto, age at about so and so, came to my office chamber and showed me a copy of work order number so and so dated 13/6/24 regarding distribution of water bottles to CM block at a contract price of rupees 3,05,000 per month till the end of contract. The work order was issued jointly to Sri Mriganko Dotto, son of so and Akash Bilas. Akash Bilas is the present petitioner. The work order bears fact signature and name and designation of issuing officer, so and so copy of this work order is enclosed. At first sight, the document appears to be a fake one. Further, I have not worked in PM Office Secretariat till now and was holding the post of Secretary Personnel so and so on a month. I heard the statement of Sri Mriganka Datta on the matter as stated. He and Sri Akash Bilas Gogoi were friends and tried to do some business contract jointly. Sri Akash Bilas Gogoi was the active partner as stated and he managed to get the work order. Sri Mriganka Datta financed as partner and gave about rupees 14
Since
lakh.
when you are behind the bars?
I was arrested on 29/7, so remanded on 29/7. So 43 days as on today. And I was 2 days in police custody, and thereafter I was not, I has never sought any police custody and never interrogated. And moreover, petitioner is suffering from the incurable disease. I have Lordship will find that page 19, page 22. So the immunity is suffering from some immunity deficiency.
AIDS.
Yes, madam. So on that ground also, and considering all the offenses, just 7 years, maximum punishment is 7 years, and he's 43 days behind a bar.
Yes.
Lordship, sufficient materials are there, Lordship, and regarding health issue, one certificate is there that he is stable now, Lordship, in the case that it is there, Lordship, and Lordship, he.
But whether he's suffering from AIDS? Yes.
And he generated Lordship, fake order used.
What is the progress of the investigation?
Initial stage, Lordship. Co-accused and Lordship, other materials, documents, Lordship, and he is sufficient materials are there, Lordship. He generated Lordship fake email, Gmail account, and Lordship also recovered fake Aadhaar card from his possession, Lordship. And also he impersonated Lordship one Shashanka by as working in CM Secretariat.
That is a work order.
And his statement, Lordship, I have flagged mark, kindly, Lordship, Paris once.
Lordship, even if then, I am not on merit, I am praying for only length of detention, offense for 7 years punishment, all out.
Heard Mr. N.K. Kolita, learning counsel for the petitioner, also heard Ms. N. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed. This application for bail has been filed. Application for bail under section 483 of BNSS has been filed by the petitioner Akash Vilas Gogoi, who has been detained behind the bars since 29/7/2025 in connection with EOB. What is EOB?
You are earlier vigilance,
EOB PS case number 1/2025 under section 120B/420/468/471 of the Indian Penal Code, read with section 66 of the Information Technology Act. the gist of accusation in this case is that on
Sorry to interrupt, Lordship. I want to also want to state that the bank details are there, Lordship, from the victim bank account to this petitioner's account, Lordship, a huge transaction, Lordship. Bank details are there, Lordship.
okay, you give me the case study.
Lordship.
I'll go through it. That on 17 June 2025, one Mr. Jadab Sakya, Secretary to the Government of Assam Power Department, had lodged an FIR inter alia alleging that one fake work order for supply of water bottles to CM block was generated at a contract price of rupees 3,05,000 per month till the end of the contract. It is also alleged that the work order was issued in the name of one Mriganko Datta and the present petitioner. It is also alleged in this FIR that the signatures of the informant as well as were also forged. In the signature of the informant was namely Shri Jadab Sakya was also forged in the said document. Learned counsel for the petitioner, on merit, what you have to say?
On
Anything?
submitting, because the CD investigation already progressed.
Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars for last 43 days within bracket since 29/7/2024. And for initial 2 days, he was also remanded to police custody. And after police custody stopped, he further submits that after remanding of the petitioner to judicial custody, the investigating officer has never interrogated him. And therefore, he submits that considering the length of detention, he may be allowed to go on bail.
One more thing here, in page 19, it is mentioned that section 35 notice was not issued. They have cited some reasons, but those are not tenable.
Learned counsel for the petitioner has also submitted that the offenses involved in this case entails punishment of imprisonment for not more than 7 years. And therefore, there was a requirement of issuance of notice under section 35(3) of BNSS. Stop. Learned counsel for the petitioner submits that no such notice was issued in this case. And the reason for not issuing the notice as mentioned in the forwarding report of the investigating officer to the learned Chief Judicial Magistrate Kamrup Metro at the time of production of the petitioner before the said magistrate does not write down the reasons for the satisfaction arrived at by the investigating officer regarding requirement of arrest in the arrest of the petitioner in this case. Learned counsel for the petitioner has submitted that the reasons, the conditions mentioned in the clause A to clause E of section 35(1) within bracket small b within bracket small Roman 2 have been mechanically reproduced in the forwarding report, which it is violation of what?
Violation of Article 21, madam.
Which according to the learned counsel for the petitioner is violation of the fundamental rights guaranteed to the petitioner under Article 21 of the Constitution of India. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the petitioner at this stage. He submits that there are sufficient incriminating materials in the case diary regarding the involvement of the present petitioner in committing the offense alleged in the FIR. She submits that the investigating officer has the investigation is at a nascent stage and some more witnesses are to be examined, as well as what is mentioned there.
Okay, case diary doesn't show that that investigation is an nascent stage.
Size.
Size reflects, my lord, investigation.
That
All details are there. That's why, Lord. All details are there.
she also submits that some more the analysis of call detail CDR, the analysis of CDR is yet to be done. And therefore she opposes the grant of bail to the present petitioner. I have considered the submissions made by learned counsel for both sides and have gone through the case diary which was produced by learned additional public prosecutor. Give me the case diary. I'll go through it and pass the orders in chamber.
Consider only length of detention 7 years.
Let me go.
Well,
Item 49.
Please, Your Lordship. Shashikar Madalala. Only victim and the informant has been examined.
Yes, what is the?
Sergeant frame under section 65(2) BNSS.
Since when you are behind the bars?
My lord, 77 days. Even today, my lord.
Date of your arrest?
27/6, my lord.
Charges are framed when?
4/8/25. 4/8/25. 4/8/24, my lord.
Let us peruse the FIR. What is the acquisition?
Yes, my lord.
Page 17.
Okay. It's number 17, my lord. The FIR is not written by the informant.
How many accused persons?
Only one minute.
But in the FIR,
Lordship, not named in the charge sheet, Lordship. No evidence were found against the others.
Okay. What is your submission?
Here, Lordship has already seen PW 1 and 2, they have done hostile.
PW 1 and 2 have been examined.
Examine and they have done hostile. Lordship will kindly come to page 70.
Page
70, 70.
Who is PW 1?
The informant.
Who is informant? Father
Father.
and 2?
Page 72.
Then what is the submission?
Lordship kindly sees the statement of the victim, Lordship. Just for a moment, page 73, Lordship.
70?
3.
This is the statement under 183.
Yes, evidence, Lordship.
Okay.
Evidence. 73, Lordship, second paragraph, Lordship will kindly see. A person came and gave me one 10-rupee note, and when I asked him what he wanted, he showed me his finger but did not say anything. The man had beard, so out of fear, I began to shout, and neighboring gathered there, and my grandmother also had. And Lordship, this, unfortunately, Lordship, if Lordship kindly goes to the CD part, Lordship, in the scan copy, Lordship will find there are a number of witnesses who have stated the same thing. The accused, Lordship, is a deaf and mute person, Lordship. And Lordship, he on that day, in his statement when he was examined by interpreter, Lordship, he also stated the same thing as the victim girl, Lordship. He went there for a cigarette, gave her a 10-rupee note, and by sign, Lordship, asked for a cigarette in this way, Lordship. She became scared, Lordship, by his appearance and his sign movement, Lordship. Thereafter, there was a hue and cry, Lordship, and then things got out of control. And there are other witnesses also, Lordship, who have seen the same thing, Lordship. I have flag mark, Lordship.
Okay. Then you are appearing for? Heard Mr. S. Gogoi, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Mr. S. J. Sharma, learned counsel appearing for respondent number 2. This application under section 483 of BNSS has been filed by the petitioner, namely Zakir Hussain Pradhani, who has been detained behind the bars since 27/6/2025, within bracket for last 77 days in connection with special POCSO case number 150/2025 arising out of Laluk PS case number 125/2025 under section 65(2) within bracket 2 of BNS, read with section 10 of the POCSO Act 2012. The gist of accusation in this case is that the father of the victim girl had, on 26/6/2025, lodged an affair before the officer in charge of Lakhimpur police station, inter alia, alleging that the petitioner had committed rape on the victim girl on 25/6/2025 during absence of any other family members of the victim girl. Learned counsel for the petitioner has submitted that the petitioner is a deaf and dumb person and has been languishing behind the bars since for last 77 days. He submitted that the victim girl and the informant have already been examined by the trial court, and they have not deposed anything against the present petitioner. He also submits that the petitioner is ready to cooperate in the trial. On the other hand, learned additional public prosecutor has also submitted that in the trial court, while deposing as PW2, the victim girl has stated that he became scared due to the gestures shown by the petitioner. He also submits that the victim girl as well as the informant both were declared hostile by the prosecution, and none of them has deposed anything against, deposed anything incriminating against the petitioner. Mr. S.J. Sharma, learned counsel for the informant, on the other hand, submits that the informant does not have any objection if the petitioner is granted bail at this stage. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the records of this case. Considering the fact that neither the petitioner, neither the victim girl nor the informant have deposed anything incriminating against the petitioner before the trial court, as well as considering the fact of period of detention undergone by the petitioner. This court is of considered opinion that further custodial detention of the petitioner may not be necessary for fair completion of the trial if the petitioner cooperates in the trial. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Special Judge POCSO Lakhimpur with following conditions, trial conditions. 2. This bail application is accordingly disposed of.
Deep level.
Your Lordship, I am not on merit, my lord. Only medical last time certificate was given. Your Lordship rejected twice, my. The third time. So he is serious about certificate I have given, and your Lordship, and is the last observation, he was admitted. And brain problem, heart problem. He requires my last page of the report, your Lordship will see. Suggested reservation practice made of regular. Your Lordship.
Which page?
This is the certificate I have given, something, the other day it is not enclosed my. After filing, he was again admitted in the hospital. This was, you know. Yes. Second page, he was admitted on 12/8, discharged on 15/8, second page, your Lordship. Review in nego OPD, a special note if any regular blood pressure monitoring, catheter clamp and release 3 hours changes over 2 weeks, physiotherapy, contact your doctor if a complaint. This is the only ground matter I have come to watch. Yes, it is there, man. The other day.
Yes, what is your submission?
Only this is the point, my lord.
On merits, Lordship, I have nothing. to
Yes,
say.
I
Two
am
times-
not.
2 times it has been rejected by law.
Yes. But I am
But
also,
your ailment is not very serious ailment.
my lord, only treatments, regular treatment. I'll appear if my lord, my appearance may be even my lord, and so that he can take a treatment, my lord, for the, just to save his life, my lord. Only this is my lord. I'm not on merit, my lord.
No, it is not life threatening.
No, my lord, this, unless we take the regular treatment, my lord, it may deteriorate my position. This, as of now, of course, not at that stage, but it may lead to that stage. That is it.
Yes, Miss Da.
Page 9 of Annexure 1, Your Lordship, where it has been stated that Ejaher, no delay has been seen, Your Lordship. After the very occurrence of the next day, Your Lordship, the FIR was lodged, Your Lordship. And 2 times, Your Lordship, their bail, anticipatory bail application has already been rejected. Finding no new grounds has been, Your Lordship, brought there, Your Lordship, stated there. So, Your Lordship, since the victim is, Your Lordship, minor girl, Your Lordship, 10 years old, and still she is a minor girl, Your Lordship. And on Your Lordship, it was very clearly stated that the A4, I would like to
Case diary is there. What victim has stated?
sketch.
On that, Lordship has already rejected the bail application. Lordship,
No, whether she was raped.
Yes,
Yes.
sure. It was
Okay.
there in medical examination report.
No, this is not a fit case.
Madam, that, I'm not merit, my lord. It will not, my lord, the medical report will say.
Learned Legal Aid Council has also submitted similar to that of learned additional public prosecutor and has opposed the grant of anticipatory bail to the petitioner. So I have considered the submissions made by learned counsel for both sides and have gone through the case diary produced by the learned additional public prosecutor. I have also perused the medical I have also perused the discharge certificate produced by learned senior counsel in support of the case.
Deeply obliged.
Item 45.
My pleasure. For 83 bail application, Lordship, today I am behind over from the database, it is 75 days. Lordship, almost all the co-accused have been already enlarged on bail, Lordship, 10 co-accused.
Where is the order?
Lordship, order from Lordship, page 52 to 81.
No, rejection order is the.
Earlier rejected, Lordship.
Your case was rejected.
Yes, second bail application, Lordship. Lordship, may I read the FIR?
No, what is the accusation?
FIR is on page 13, is a type group.
What is your name?
I am Rishiraj Hazarika.
How many other accused persons were there?
At least almost 10 are, I know up to 10, so 10 have already been enlarged on bail. This is the main accusation against three accused persons. It is
Yesterday also two petition moved, not all regularly, other persons also arrested subsequently.
I am on Rishiraj Hazarika losses. I am 75 days behind the FIR losses. Now I want to submit this to the FIR page 13 is the type copy losses. May I read the FIR losses? With reference to the subject cited above, I have the honor to submit that reliable and actionable intelligence has been received from a credible source indicating the presence and operational activities of certain overground workers or linkmen of the prescribed organization Alpha Independent in Guwahati. As per the input, these individuals have allegedly established a covert base in the Guwahati city with the intention of orchestrating of subversive and anti-national activities, including but not limited to waging war against the state in furtherance of objective of the said band outfit. The information further reveals that the aforementioned individuals are directly associated with them.
Who are named?
The name Joseph, see page 14 at bottom, Y name Kha, and page 15,
Yaman Konya.
Yaman Konak and S Konak. They are the allegation against, specific allegation against 3 persons.
Okay.
Now,
What is their status? Whether they are released on bail or?
this is a page 52, page 52 also.
Okay.
Page 52.
Now, what is your case that you are not involved?
Already rejected one of his case, page 94. It is rejected also. On that day, I am not prepared, or it was on only 30 days. On that day, I was not well prepared. Today, I have the 8 bail orders for 10 co-accused. The main 3 are already announced.
Rejection order is at page 90.
4. Yeah, but it is terms of considering the stage of investigation at this stage. By stating that the bail petition was rejected on that day. At page 97.
How many days have lapsed in the date of rejection?
It was rejected at that time 38 days. Now it is 75 days. Those kindly produce one order. Those out of 10, 6 co-accused enlarged by this honorable court itself. Kindly produce a page 76.
No. Assuming that other accused persons have been released, but your case was rejected, how you will overcome that?
No, Lordship, I want to show, Lordship, see page 76, the allegations of page 76, the observation of this honorable court.
Yes.
And therefore, another following report I will show, Lordship. Firstly, this page 76, the bail order of one Asapuddin. When he was completed 71 days, he was enlarged on bail. Now the observation of this honorable court, the page 79. Page 79, the para 11. It appears from the case that in this case, the accusation in the FIR has been leveled specifically against 3 accused persons named in the FIR. It also appears that the said accused persons have already been allowed to go on bail by the coordinate bench of this court in bail application number so-and-so on 18/6/2025. Apart from that, another co-accused, namely Topon Roy, has been allowed to go on bail by the coordinate bench of this court on 27/6/2025 in bail application number so-and-so. Now, para 12. Though there are incriminating materials, the present petitioner in the case diary, however, it appears that the petitioner has been detained behind the bars for the 71 days. And considering the period of detention as well as progress made in the investigation, further custodial detention of the petitioner does not appear to be necessary for fair completion of the investigation of crime branch case number so-and-so if the petitioner cooperate in the investigation. For the aforesaid reasons, the above petitioner is allowed to go on bail. Let us. And another order was page 81. Same observation was followed. And next,
but your last order was rejected that you do not stand on the same footing.
Now I want to show one other co-accused forwarding report. This is page 85. Page 85. Kindly please, page 85. On that day, that is my bad luck. I was not prepared. So page 85. Others, I was on the same footing. Page 85. The bottom, the para 1. It is a forwarding report of Topon Roy. Page 85. At the bottom, it is para 1.
Yes.
During thorough interrogation of the ground of arrest, during thorough interrogation of the already arrested accused person, namely Biswajit Rai, it was learned that he was recruited in the Ben organization Alpha A through the below noted accused person, that is a Topon Rai, which reflects involvement of the accused with the Ben organization.
Now, Topon Rai has been granted bail.
Yeah,
where is that?
It is page 56. Page 56, on the same footing.
Yes, Mr.
Yes, page 56. Okay. When he was completed only 55 days.
Okay, Mr. Parashar.
75
Lapse of the.
Yes, first 3 persons were named in the FIR.
They were released.
They were released. It was placed before the court that they were working in a restaurant only. All people from Nagaland, and they are collecting information and the list of persons, collecting phone numbers from whom extortion can be made and forwarding them to the ban organization. Now this person, he earlier here, tried to surrender and all this, there are materials. Otherwise, now today I got the information from the IO itself, this person already taken into custody in another Lakhipur PS case number, that is also UAP already.
That is not related with this case.
Otherwise,
That is not related.
no, I have,
In this case, do you require his further?
materials are there.
His statements are
All are there.
okay, heard.
Case is not related.
No,
to this.
not related.
No, that's Page number 81,
I am
Lordship.
placing,
I am
because
also another forwarding report, Lordship.
Because-
Page 81, Lordship. Can you see?
I am
Because
placing
page
because of
88.
all persons are.
Page 88.
Okay, heard Mr. P. K.
more
Surya,
than-
learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Rishiraj Hajorika, alias Huntu, alias Danish Assam, who has been detained behind the bars since 27/6/2025 in connection, within bracket, for last 88 days,
75 days. 75.
or last 75 days in connection with crime branch PS case number 2/2025 under section 61/2/147/3082 of BNS, read with section 10/13 of the Unlawful Activities Prevention Act. The gist of accusation in this case is that quote para 3 from page 60. Learned counsel for the petitioner has submitted that the petitioner is approaching this court seeking bail for the second time. Stop. His earlier bail application was rejected by this court on 4/8/2025 in bail application number 2308/2025. Learned counsel for the petitioner submits that when the petitioner moved the earlier bail application, he had been detained behind the bars for only 38 days. However, now he is languishing behind the bars for last 75 days. And in the meanwhile, almost 10 of the co-accused persons have already been released on bail. Learned counsel for the petitioner submits that one of the main grounds for rejection of bail on the earlier occasion was that the accusation made against the petitioner was that he has been involved in recruitment of fresh people, fresh recruits in the proscribed Alpha organization. And his case stands on a different footing from the persons to whom bail were granted. Stop. However, learned counsel for the petitioner submits that a co-accused, namely Tapan Roy, against whom also the acquisition of recruiting persons in proscribed Alpha organization Alpha 1, Alpha I was made, has been granted bail. Where is his bail order?
Page 56.
Granted bail by
Page 56.
by a coordinate bench of this court. And therefore, he submits that the petitioner same petitioner stands on the same footing like that of Seth Tapan Roy. And on that ground also, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has submitted that there are sufficient materials in the case diary against the petitioner. He also submits that the petitioner has also been found involved in connection with another case of similar nature where he has been shown as arrested. Stop. I have considered the submissions made by learned counsel for both sides. It appears that were you in police custody also? Whether you were in police custody also?
Yes, sir. In this case, I have been taken for 14 days in police custody.
Okay.
I have annexed the orders.
It appears that the petitioner has been detained behind the bars for the last 75 days, out of which he was in police custody for 14 days. Therefore, there is a presumption that he has been thoroughly interrogated. Stop. Further, the case diary, further on perusal of the case diary, it appears that though there are sufficient materials against the petitioner in the case diary, the investigation as regards his involvement has been fairly progressed and stop. This court, considering the progress in the investigation as well as period of detention undergone by the petitioner, is of considered opinion that if the petitioner cooperates in the investigation, his further custodial interrogation may not be necessary for fair completion of the investigation of Crime Branch PS case number 2/2025. For the aforesaid reasons, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro.
May I please, decision sessions as Kamrup Metro.
Yes. And learned Session Judge, Kamrup Metro, with following conditions. Condition number 1 and 2, investigation condition. Send back the case diary. This bail application is accordingly disposed of.
Deeply obliged, sir.
Item 49.
For 482 bail application, my 60 days fixed for CD.
Is there in there?
49. It is.
Your own CD is there. The petitioner has appeared. Heard Miss, what is your name? R. Begum, learned counsel for the petitioner. Also heard Miss N. Das, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was granted interim bail by this court on 2/6/2025, and in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Karupetia PS case number 21/2025 and has submitted that the petitioner has appeared before the investigating officer and his statement under section 180 of BNSS has also been recorded. Stop. Considering the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim bail granted to him by order dated 2/6/2025 is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact. Send back the case diary. This anticipatory bail application is accordingly disposed of.
They did not receive that.
21C CD would be required. Heard Mr. U. Chaudhary, learned counsel for the petitioner. Also Ms. N. Das, learned additional public prosecutor, who prays for some more time for production of the case diary. Prayer is allowed. Let this case be listed on 18/9/2020.
Ordered item 52 and item 54.
Yes, Your Lordship. Here in this case, Lordship, I have challenged the FIR, Lordship, and during pendency of that case, Lordship, that interim order was there to take no coercive action. And now, Lordship, charge sheet is submitted, the case is pending before the court, Lordship. Therefore, I have filed this interlocutory application praying for staying the proceeding, Lordship. Lordship, may kindly see the FIR.
No, why stay of proceeding?
Because charge sheet is now submitted, Lordship, before the court and summon is issued.
No, why proceeding should be stayed?
Because
you have challenged the FIR.
Yes,
And that
already
is,
there is an order of taking no coercive action against the petitioner. The submission of charge sheet also includes coercive action.
no.
That Supreme Court judgment is there, one.
Is it?
Yes, Lordship.
Whether submission of charge sheet
Yes,
is
so in that case, contempt proceeding was drawn against the investigating officer.
for filing charge sheet?
Yes, during there was an order for taking no coercive action. That was interpreted in that.
But in this Niharika infrastructure, the court has, Apex Court has observed that what coercive action means, it has to be clarified while passing such orders.
This is subsequent to Niharika.
Show me.
I will place that there.
Today,
And in fact, if your Lordship see the FIR also, they are purely a civil dispute. He says, Lordship, that he has lost one checkbook which was kept in his house. Subsequently, the petitioner has withdrawn that amount. And in this regard, already earlier the dispute is going on between the party and to the authorities also. They have since 2022 they have written those facts to the authorities also. It is not, and the FIR was lodged in the year 2024.
what is this? What is the stage?
Now, charge sheet is submitted for appearance.
When is the date fixed?
Lordship, it is fixed on 9th.
9th of?
4 October, 4th October, Lordship. 4/10/25. That I have enclosed that order. And FIR also do not disclose any cognizable offense, Lordship.
No, then we'll issue notice in the interlocutor.
Already notice served to him, Lordship. Office notice there. He is not coming up before this court. In main case, already notice served. Office notice there.
Okay, yes. Where is that? That coercive action means.
I will place after some time, but just I am getting the printout or I will send him the copy.
Yes, what is your submission? Whether we can hear this criminal petition
Today
for
it has
this.
come up for orders.
Now, orders, and that order IA only. Otherwise, to dispose of the main petition, that record should be called for, my lord.
Records are not there.
Already succeeded.
what we will do with the IA?
I am already defend that order has been passed, otherwise not specific, but against full of Kolita is there
In main case, main case. Main case means item number?
52.
Item number 52. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. On perusal of the office note dated 8/9/2025, it appears that the AD card AD card issued along with the notice issued to respondent number 2 has been received back. With full signatures of one Mikhail Kakoti thereon. Who is Mikhail Kakoti? He is not the
One is Prasanna Kakoti. It was sent to his office address and his residence.
no, unless we know who is that. What is to be done?
It's done, but that instruction. Okay.
You find out who is Mikhail Kakoti. Okay. You also submit that.
Yes.
For IA. Part dictation will continue. After some time we'll take. You find out from your sources who is Mikhail Kakoti. Yes.
Little or condonation of delay of 357 days.
What is the reason for delay?
There might be an issue regarding maintainability, my lord. This order is, my lord, passed by family court. So perhaps it will have to come before the
Division bench.
Division bench.
What is the order?
My lord will have page number 8. Judgment has been passed by my lord family court Barpata.
What order?
Final judgment, my lord.
125.
125.
Where is that provision that?
It's in the family court act, my lord. Any order, whether it is final or interim,
Family Court Act.
has to be by way of an appeal, my lord. Appeal lies.
An appeal lies before the division bench.
Yes, but it will not be revision, my lord. This is the revision, my lord. So criminal revision.
What is your response to that? Maintainability.
My senior out of station today. I have
Okay. We'll give them chance to respond. Heard, Mr. What is your name?
M. Rahman.
N. Rahman, learned counsel appearing for Mr. N. Ahmed, learned counsel for the applicant. Also Mr. S. Das, learned counsel for respondent number 2, as well as Mr. K.K. Parashan, learned additional public prosecutor. Learned counsel for the which provision?
19, my lord. 19 of the family code.
Learned counsel for the respondent number 2 has raised a question of maintainability of this criminal revision petition on the ground that the impugned order in this case was passed by learned Principal Judge, Family Court, Borpeta,
Borpeta, my lord.
Borpeta, and as per section 19 of the Family Courts Act 1984, appeal lies against
Any judgment or order.
any judgment or order passed by the family court to the High Court. And therefore he submits that this revision petition is not maintainable. On this, learned counsel for the petitioner submits, Mr. N. Rahman submits that he may be granted some time to respond to the question of maintainability raised by the learned counsel for the respondent number 2. The prayer is allowed. Let this case be listed again on
Next week.
24th of September.
Highly obliged.
Board admission item 20.
I am appearing for the sole respondent.
May I please, your lordship, my senior is on leg in another court. May this matter be called for after some time?
My lord, records are not there, my lord. Record.
Our records have not been received.
Fresh, my lord, requisition.
Heard Miss records are ISN.
Office notice there.
Heard Mr. A.C. Vishwas, learned counsel for the petitioner. Also heard, what is your name?
K. Uddin, man.
K. Uddin, learned counsel for respondent. On perusal of the office note dated 26, office note dated 8/9/2025, it appears that the trial court records has not arrived from the Court of London, Additional District Magistrate. What is this? This is a
144 initially drawn up, then it was converted to 145. There was a judgment which was under challenge by them.
judgment against judgment of
Asian Court we have come. Asian Court has altered the judgment of the additional district magistrate.
Trial court records have not yet arrived. Issue reminder for the same. The registry to issue reminder. Let this case be listed after 4 weeks on a date to be fixed by registry.
Registry. Well, there is a status order.
The interim order shall continue till next day.
Right.
21.
Your lordship.
Yes.
Your lordship, this is a criminal revision petition filed under section 401, read with 397 CRPC, your lordship. We are challenging the judgment and order passed by the learned session Judge Morigaon, upholding the order passed by the learned SDGM Morigaon, wherein the client has been, the petitioner has been given conviction of simple imprisonment for 6 months, Your Lordship. The case is yet to be admitted. The case may be admitted at this stage, Your Lordship, and we may be granted the interim.
Whether notice has been issued?
Notice has not been yet issued.
No,
It's first time for the admission column, Your Lordship.
the delay has been condoned.
Delay has been condoned.
Okay. Third, Mr. What is the name?
Mr. A.N. Iqbal.
A.
A.N.
N.
Iqbal.
Iqbal, learned counsel for the petitioner. State is a party.
It is a party.
Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 401 of BNSS, 401 of the criminal, of the Code of Criminal Procedure, 1973. You check your cause title. 1973.
1973. Sorry.
Impugning the judgment and order dated 8/6/2022, passed by learned session judge Morigaon in criminal appeal number 17/2019, whereby the judgment and order dated 8/4/2019, passed by learned subdivisional judicial magistrate Morigaon in GR case number 2858/2015, whereby 2858/2015 was upheld. By the aforesaid judgment, the trial court had convicted the petitioner under section 498A of Indian Penal Code and had sentenced him to undergo simple imprisonment for a period of 6 months. Is there any interim prayer?
Yes, Your Lordship, there is an interim prayer. Till disposal of this revision petition, the sentence may remain suspended.
Let the note, you are on bail.
Not on bail, Your Lordship. Considering the fact that another court has granted interim in respect of criminal revision, usually it is granted, Your Lordship, in respect of such offences.
Issue notice to the respondents. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to the said respondent. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon the said respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Stop. Since the sentence imposed on the petitioner is for a short term of 6 months only, during the pendency of this criminal revision petition, the execution of the sentence imposed on the petitioner is stayed and he is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the learned subdivisional judicial magistrate Morigaon in connection with GR case number 2858/2015, with a condition that in event of dismissal of this criminal revision petition, he shall surrender before the trial court to serve out the sentence imposed on him by the impugned judgment, list accordingly. Yep.
I have given that copy to a.
Your item is 52. 52 half dictation হয়েছিল। No, small order. I'll repeat it. No, who is?
That Mikhail Lordship that I have obtained, tried to obtain instruction, and he said, Lordship, there is no such man in his house. He intentionally to avoid the service, he has put the signature. The informant has put. No such person is there in his house, in that name.
But how will we know?
That is my instruction that I have.
You take fresh steps through jurisdictional police station.
But Lordship may state that proceeding, Lordship.
No, we'll go to that first. In item number 52, heard Mr. A. Ahmed. Yes. Vishal Mikhail. Learned counsel. Learned continue, para 3. Learned counsel for the petitioner submits that he has been informed that there is no person by the name of Mikhail Kakoti in the family of the respondent number 2. Stop. Considering the submissions made by learned counsel for the petitioner, the petitioner is directed to take fresh steps for issuance of notice upon the respondent number 2 through officer in charge of jurisdictional police station within 3 days from the date of this order, returnable after 4 weeks. List accordingly. The item number 64. Yes, where is that?
That is Satish Kumar Ravi. May I read that?
Yes, please read.
Peruse the affidavit of Sri Deepak Kumar, Deputy Superintendent of Police, Sri Swanso Investigating Officer, and Sri Swanso Station House Officer. They have stated that they read the order of this court with which directed them not to take any further action against the petitioner as an order directing that no coercive action shall be taken against the petitioner. They have relied.
There is a difference. In this case which you are referring to, the direction was no further action.
No, here subsequently it is clarified, Lord.
Okay, please read.
They have relied upon a letter dated 15 April 2011 addressed by the Additional Director General of Police, Jharkhand, to all police officers in the state. It is stated in the letter that even if court passes an order that no coercive action shall be taken as against the petitioner particular accused, there is no prohibition of filing charge sheet against the accused. If a charge sheet is filed by relying upon clause 3 of letter dated so against an accused in whose favor there is an order directing not to take coercive action, the concerned officer will expose himself to contempt jurisdiction. Therefore, what is stated? So this was subsequently forwarded to officials.
Charge sheet is fine. It is not very clear. whether
No, there, Lordship, in the letter, it was of the official
it refers to a
department.
letter.
Yes, there is a departmental order which says that charge sheet can be filed even there is a direction for not to take coercive action. And Supreme Court says if relying on that letter, someone filed charge sheet, he will expose himself to contempt jurisdiction. Because that cannot be filed.
But this does not clarifies what coercive action means.
That your Lordship will see at the time of filing final hearing, but at this stage, Lordship may stay the proceeding.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This interlocutory application, whether notice will go.
In the for prayer of stay, Lordship may consider, because in first day also we normally pray for stay and Lordships consider that aspect.
This interlocutory application has been filed by the applicant by praying for stay of the proceedings of, praying for staying of the proceedings of PRC case number 2046/2025 pending before the Court of Learned Additional Chief Judicial Magistrate Kamru during the pendency of connected criminal petition number 328/2024. Learned counsel for the petitioner has submitted that in the aforesaid criminal petition, by when the order of no coercive action,
That was
by order dated
21/3/24.
21/3/2025,
24.
2024, this court directed that no coercive action should be taken against the petitioner. However, in the meanwhile, charge sheet has been laid. Learned counsel for the petitioner submits that when an order for not taking any coercive action is passed by a court in a criminal proceeding, even the charge sheet may not be filed, as filing of charge sheet during subsistence of such a order of not taking coercive action would subject the concerned officer to contempt jurisdiction of this court. In support of this, his submission, learned counsel for the petitioner has cited a ruling of the Apex Court in Satish Kumar Ravi versus State of Jharkhand, within bracket order dated 29/11/2024. 29 passed in appeal within bracket criminal number 9859/2023. Stop. Issue notice to the respondents. Since learned additional public prosecutor has appeared for the respondent number 1, no formal notice need to be issued. As against respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon the said respondent through the officer in charge of jurisdictional police station within 3 days from the date of this order, returnable after 4 weeks. Stop. Though the Apex Court has observed in the case of the Harika Infrastructures Private Limited What's the state of, what is the citation? Do we have? In bracket. Criminal Appeal number 330/2021. That while passing an order for not taking any coercive action, the courts should clarify as to what it meant by the phrase coercive action. However, in view of the ruling cited by the learned counsel for the petitioner, in this, yes. The judgment which you have cited is not very clear. It relates to the letter where in clause 3 something has been mentioned. We don't know what has been mentioned.
Submission is on merit, Lordship. That already that is there. Therefore, I have pointed out to your Lordship. And where the charge sheet is submitted, that is not also there.
Putul, inneke di diyo. Yes.
Lordship will kindly peruse paragraph number 3 for a moment, Lordship.
Yes.
The subject matter of challenge in both matter is an interim order passed by the High Court saying that no coercive action be taken against the original accused persons against whom the FIR has been registered. Now, Lordship will kindly come to paragraph 5. We take notice of the fact that almost 1 year has elapsed since the High Court issued notice and granted interim protection to the accused person. 6, Lordship, we are informed that although the High Court protected the accused person from any coercive action being taken, yet the investigating agency has construed that this interim order as one staying the investigation. 7, Lordship, according to the learned counsel, the police has not undertaken any investigation so far. Paragraph 8, we are informed that the matter is coming up for hearing before the High Court on 16/4/25. First, we want the High Court to inquire with the state whether the investigation has been undertaken or not, because it has not stayed the investigation. Thereafter, Lordship, if the investigating officer has not undertaken any investigation so far, the High Court should ensure that the investigation is undertaken at the earliest in accordance with law. The High Court also should ascertain from the state whether the accused persons have appeared any time before the investigating officer for the purpose of interrogation or not. Ordinarily, in a quashing petition, the High Court should not pass an order that the IO shall not arrest the accused person. If the High Court is more than prima facie convinced that no case is made out or the complaint fails to disclose commission of any cognizable offense, it may consider to stay the very investigation, but should be loath to pass an order that no arrest shall be effected. So, impliedly, Lordship, it means that no coercive action means that the petitioner should not be arrested. It does not mean that the investigation should be.
No coercive action here, from here, what I have understood, that is, there is no dispute on that issue. Because if no coercive action order is directed, then Lordship, that investigation will carry out by the IO, Lordship. But only thing is that whether charge sheet can be filed or not, that is a different aspect. It is investigation cannot be halted for that order.
So if the investigation is not halted, Lordship, it will result in either way, Lordship, either the charge sheet or the final report, Lordship.
No, but the observation that the officer filing the charge sheet
Yes.
may be liable to contempt.
Down the case.
Yes, background has.
Here, Lordship, it is absolutely clear, Lordship. It has impliedly stated, Lordship, that directly stated, Lordship, that it does not mean stay of investigation. If I may just point out once again, Lordship.
The investigation cannot be stayed. That
Then, Lordship,
there.
if investigation is not stayed, Lordship, then it will culminate into either charge sheet or final report,
So
Lordship.
they have to submit charge sheet with the leave of the court. That is the only distinction. Lordship. They can
No.
carry it out because suppose a incident occurred and I obtained the order of
Yes,
no
that may
coercive
be,
action.
that appears to be reasonable submission,
Regarding, Lordship.
that leave of the court
Yeah.
before filing charge sheet.
That
You
is
carry out the investigation as because there is a. We'll examine these questions. Now, क्या लिखा? Petitioner, the উপরতে এটা paragraph add করিব. Learned additional public prosecutor has, on the other hand, placed a ruling of the apex court in the case of Satish Kumar Ravi versus State of Jharkhand, within bracket order dated 29/11/2024.
relied
Oh,
on.
no, sorry. No, ruling of the apex court in the case of Nazma Aslam Merchant versus State of Maharashtra and others reported in within bracket order dated 28/3/2025, passed in specially petition within bracket criminal diary number 15379/2025, wherein the apex court has observed that the use of phrase no coercive action would not debar the investigating agency to continue with the investigation. Stop. On this, learned counsel for the petitioner submits that there is no dispute that investigation may be continued. However, he submits that in view of the judgment of the apex court in the case of Satish Kumar Ravi versus State of Jharkhand within bracket Supra, if on culmination of investigation during the subsistence of an order of within inverted comma no coercive action, before filing the charge sheet, the investigating officer should obtain leave of the court which had issued the order of no coercive action. So, episode क्या था last? Petitioner, till next returnable date, the further proceeding of PRC case number
2046 2046 of 2025.
2046/2025 pending before the Court of Learned Additional Chief
Kamrup
Judicial
Metro.
Magistrate Kamrup Metro is hereby state. List accordingly.
Lordship has directed to take step in both the cases.
Yes, yes, both the cases.
Problems.
Yeah, please, Lordship. My lord, this case is for quashing the FIR and charge sheet against the present petitioner.
Lordship may kindly see the FIR page 14.
Whether the trial court records are there, I say,
Lord may kindly see the last order.
yes.
Today was fixed for consideration of interim pair.
No, we'll dispose it off if the records are there.
See, what is my submission in this pilot? I have a shop.
Yes.
Now, one person, Hyder Ali Borvia, he is an accused in this case. And I am Arif Ahmed. I have a shop at a bazaar near the Murazar police station. So computer shop, different persons come to me for identification, identity card binding, etc. So in that manner, this Borvia came to my shop for binding his identity card.
What is your name?
My Arif Ahmed.
Arif Ahmed.
Yes. In the FIR
Co-accused
is Hyder Ali Borvia.
Iqbal.
Huh?
Iqbal Haider Barwan.
Arif Ahmed, yes.
Now, Lordship would kindly say that what is the benefit of this present petitioner? Iqbal Haider Borvia came to my shop to bind his identity card. Now it is his card. If I pierce the card and make a new card, what is my benefit? Ultimate beneficiary is Iqbal Haider Borvia. And I have a shop, that is my source of livelihood. So my submission is very short that I am not the beneficiary. Kindly consider, when I am not, so if there is any benefit, that benefit will be derived by Iqbal Haider Borvia or anybody else who has committed this fraudulent act. But I have bind the
What is the allegation of forging the I-card
I-card, yes, that is.
or any other allegation?
In FIR, my name is not there. But it is said by police, this Borvia said that I have prepared this ID card in the shop of Arif Ahmed. Now, if I prepare the ID card, bind it, what is my fault? Because that is my business. And if I made a false ID of Iqbal Hussain Borvia, Iqbal Haider Borvia, then what is my benefit? Who is the beneficiary? Very simple question. I am not the beneficiary. And there is no allegation that I have taken some money from here, extra money, the limited money which I take to use from other customers. So unnecessarily, my lord, what will be the, in the long run, what will be the fate of the case? Because Lordship is aware that the person must be the beneficiary. And I am not the beneficiary. Beneficiary may be.
At this stage, how we can say, unless evidence is adduced. Now, the investigation has been completed. Charge sheet has been laid.
Completed.
So something has been found against you.
No, something has been found, my lord, that I have mentioned in my here the charge sheet. This Borvia said that I have made this identity card in the shop of Arif Ahmed. So that is the reason. Now, what will be my role? Now, can you see the charge sheet, page 37.
Is it a case that there is no material against you in the charge
Yes,
sheet?
nothing is there.
only saying of this Iqbal Haider Borvia that I have prepared this, but there is no other witness. This is the allegation. Then, my lord, if you, some persons, I purchased some materials from a
Okay,
shop,
voter I card, fake voter I card.
a fake voter ID. Now, that is also a question. If I make a fake voter ID of Iqbal Haider Borvia, what is my benefit?
No, that we don't know now. Without going through the records.
That's why that was called for. But temporarily, my lord, my submission is this. This case has, and an important thing is this, there are two important prosecution witnesses, Lordship may kindly see page 37. Witness, Gyasuddin and Toibur Rahman, page 37,
Oh,
Lordship.
are you ready to for final hearing?
Record. Otherwise,
Records are there.
records are there. Otherwise, voter ID can be used for getting several benefits. Beneficiary to voter ID is must. And if some people is helping to get that benefit, his role has to be.
You are for?
My lord, I am appearing for respondent number 5, that is private respondent.
Iqbal.
Iqbal,
He is the main person.
I am,
He is the main-
what happened in this case, my lord? I was applying for passport. And while applying for passport, that I was caught using the fake voter ID card, my lord. Lordship may come at page number 32, my lord.
In your case is that this fake ID card was given to you by,
What happened in this case, my lord? The voter ID card which was issued to me, in that my name was written as Muhammad Iqbal Haider Borbuya. Spelling, there were mistakes in spelling.
EK.
EK. It should have been IKBAL, and instead of HY, it should have been HAI, my lord. So, since the petitioner is running a shop, making PAN card, Aadhaar card and all, so I went and approached him whether he can apply for correction of my voter ID card. And in that case, he said he can apply for correction of the voter ID card. So for that, I made the payment to him. And after 5 days, he received my original voter card also. After 5 days, he called me over the phone and he handed over me the voter ID card. And with that voter ID card, I went to apply for passport.
no, we'll hear it finally.
My lord.
With that. But the important two witnesses, which are charged witnesses, they said that I am not involved in this matter. My learned friend has stated that he has given to correct it. So correction and fraudulent activity is totally different.
No, we'll hear it finally. You choose a date. You are ready today?
So time will not permit.
Yes. Before vacation, you may choose a
Yes,
date.
next week, any hearing day. Either Tuesday or Thursday.
Heard Mr. Mahmood Ahmed. Sorry, heard Mr. M.U. Mahmood, learned counsel for the petitioner. Also heard Mr. K. A. Basumatari appearing for respondent number 5, as well as Mr. K.K. Parashar, learned additional public prosecutor appearing for state respondents. It appears that the trial court records have been received and this case is ready for hearing. So, however, then an additional public prosecutor submits that he needs some time to go through the records before he makes his submission. Considering the submissions of learned counsel for the petitioner, this criminal petition is admitted for hearing and fixed on
Tuesday or Thursday next week.
next to next week. on 23rd. Fixed on 23rd September for hearing.
It has been received.
Yes, what is the matter?
By this petition for quashing the FIR. Your Lordship. This FIR is a total misuse of POCSO Act. Your Lordship. Can you please the page 10 is the FIR?
It is pending investigation.
Yes.
Page number
10. 10.
8.
10.
10. Yes.
So can you please the insert executive outpost and the date is important 10/11/10/2024. For the executive respect, I have the honor to inform you that on 28/9.
Hello.
Also does not require any more judgment. There are number of judgments. Not necessary, Lordship.
Not necessary. Item.
Please, Your Lordship. My Lordship, the conducting counsel in this matter, Mr. P. Chaudhary is out of station today, Lordship. Only matter may be adjourned for the day, Lordship.
Today, actually, we don't have time also.
On 16th or 17th, Lordship.
Lordship, before Puja vacation, it is not possible for my conducting counsel, Lordship.
We have certain urgent nature, Lordship. This is a case of NI and the huge amount of money has been used by this accused appellant, Lordship.
Lordship,
So, and
Okay. Now let us see when it is possible. Heard Miss P. Soikya. Heard Miss. You are for, there is.
P. Chaudhary.
Heard Miss B. Goswami, learned counsel submitting on behalf of Mr. P. Chaudhary, who prays for an adjournment on the ground that the conducting counsel for the petitioner is out of station. Miss M. Chaudhary, N. Chaudhary, learned counsel for respondent number 2, has respondent number 1. Learned counsel for the respondent has prayed for listing, has submitted that there is urgency on the part of the respondent, as huge amount of money of the respondent is involved in this case. She therefore prays for, she, while not objecting to the prayer.
no objection, but there is time.
Okay, she on that ground, she has objected to the prayer for adjournment. Stop. I have considered the submissions made by learned counsel for both sides. Today, otherwise also due to paucity of time, this matter may not be heard. It is not possible to hear this matter. Hence, the prayer for adjournment is allowed. Let this case.
Lordship, October 16 is not possible, Lordship. Lordship, kindly, matter may be admit or final hearing, Lordship, after Puja, Lordship. 16 October is not possible. 16 October, Lordship, not possible.
16 October is after Puja only.
After Puja, but the conducting counsel sister-in-law is wedding, Lordship. 16 October, Lordship, 15 and 16.
Lordship, may I submit?
23rd October for final hearing.
Yes, Lordship.
They have put the interim order on the last.
Interim is
occasion.
also there. But
Lordship,
No, Lordship, no information regards this settlement. And Lordship, on the last occasion, Lordship, interim order has been granted by the Honorable Court in absence of the respondent. In spite of the fact that in the delay condemnation petition, we have appeared, our color number was there, but in the criminal division petition, the name is not in the cause list.
And after getting the order, Lordship, they have informed that the matter was listed before this court. And in spite of the order in delay continuation, Lordship, the Honorable Court directed them to furnish the criminal revision petition, but they have till date not served the same.
Lordship,
So I have
already
objection
issued
and
notice, Lordship.
humble
No.
request. Lordship.
You, while taking the benefit of interim order, you have to abide by the by the directions of the court. If there is an allegation of not following of the guidelines or directions, then the interim order is liable to be vacated. Therefore,
There is some difficulty.
okay,
inform
we
others also.
are allowing your prayer, but not after puja, before puja at that date. You come prepared. Yes.
Kindly, 23rd October may be prepared.
No. Before puja, we will consider to whether to extend the interim or not. 25th of September. The interim order shall continue till next day.
Lordship, in the meantime, a direction may be given to furnish the criminal.
That direction is already there. You furnish. Otherwise, we'll vacate the interim order.
Item number 27 may be taken on Monday also.
No, Monday may not be possible. If you give us dates without knowing what is on our board,
16 Lordship,
item number
27.
Ketia Paribu. Yes, because last week is likely to be the motion week.
11 on April it was filed, but till that no hearing taken place, not even a single.
No, but we cannot help. Unless in the,
Any date or next week.
what is the urgency?
Because his personal liberty is Mr. Lordship.
What is the case?
Case is, the Lordship, his case is filed because not serving the summon to him, but the case is already, all the co-accused are acquitted in the matter.
And you are behind the bars.
Not behind the bar.
Then there is no urgency.
But he has to appear in other cases also.
Due to paucity of time, this matter could not be taken up for hearing. Item number 3. What your name is M.K. Sharma?
S.V. Prasad.
Mr. H.B. Prasad, learned counsel for the petitioner, heard Mr. H.B. Prasad. This matter could not be heard due to paucity of time. Let the registry fix this case. On a convenient date to be fixed. Let the registry decide. You pray before registry.
Maybe the Lordship, item 29, Lordship, I'm for the petitioner. We have an interim Lordship, I pray that the interim may be continued.
Wherever there is interim,
Also, Lordship, a similar matter is fixed on 16 October, Lordship. Lordship, let the matter be fixed on 16 October, Lordship.
similar or
Similar as in Lordship, this is the third FIR which we are challenging. Lordship, a similar matter pertains to the second FIR, which we have already challenged. And there is a stay order in the second FIR regarding the second
heard
FIR.
Ms. R. Burwa, heard Ms. P. Burwa, learned counsel for the petitioner. Also, standing counsel is there. This matter could not be taken up due to paucity of time. Learned counsel for the petitioner submits that a similar matter in relation to the same fact,
Lordship, same cause of action. Lordship, a second FIR was
in
filed.
relation to the same cause of action is pending before this court, and the date is fixed on which date?
Lordship, on 16.
On 16 October. Learned counsel for the petitioner prays that this criminal petition may be listed with the said case. The prayer is allowed. The registry to list this matter on 16th of October along with criminal petition number
2024.
127/2024. The interim order shall continue till next day.
Lordship. With the consent of others, said Lordship, I beg to mention item number 28, Lordship. There is matter may kindly listing on 25 September, Lordship.
Twenty-five would be the motion be,
That
motion
24
be.
possible.
So
Or immediately after
listing would be
vacation,
futile
immediately
after vacation. This matter could not be taken up due to paucity of time. Let this matter be listed after Puja vacation on a date to be fixed by registry.
Lordship, I am appearing for a private respondent number 2. My name has not been shown in the cause list.
Heard.
M. Pathak.
Means registry is directed to reflect the name of Mr. M. Pathak as engaged counsel for the private respondent. That is private respondent number 2 in henceforth.
Obliged, Lordship.